Criminal petition. Friday or Monday, my
Listing.
listing. Criminal petition, my lord. Matter was last filed on 26/6/2025. But till now not listed, my lord. Friday or Monday, my lord?
Monday.
Monday. Oblige.
Maybe. Email appeal, my lord. Earlier it was 6 times left over my. Well, 9 times it was listed.
No, we are not taking the regular bench. You can make a mention before the registry.
But
If the matter is rejected by this court, then definitely it will come before this court.
no, my best email appeal, my lord. Earlier it was listed.
Pardon? What are you saying?
Email appeal, my lord. Earlier it was listed because your lordship 6 times left over my. I'm paying for listing, my lord.
Of praying for listing of
My-
criminal appeal.
My lord.
Uh,
2-3, my lord. September 2-3.
it is a hearing column or what?
Orders, my lord.
In orders column.
Order.
I don't know.
I is there, my lord.
তেওঁলোকৰ এইখন communication form উলাই লৈছে নেকি? এইটো কথা কৈছে। মানৱ কি বাহিৰে? Thursday, 4th of September.
My lord.
4th of September, Thursday.
Can it be, my lord, 3rd or 5th, my lord?
5th.
My lord.
May it please your lordship, I beg to mention for listing of a part-heard matter, criminal petition. It was last listed in the year 2024 in the month of June.
By this court only.
No, by the Honorable Court of M.K. Kolita.
তাতে বেশ হব কি কৰিব এই ডাটাটো? মোৰ কাৰণে প্ৰেয়াৰ কৰিম এইটো কথা না মই আমাৰ তাত নকৰোঁ লিষ্টিঙৰ প্ৰেয়াৰটো টিউজডে কাৰণে টিউজডে নেক্সট টিউজডে হিয়াৰিং ডে নেক্সট টিউজডে
Oblige.
May I please? I beg to mention for listing on criminal petition, lordship.
ক্ৰিমিনেল
Criminal petition, lordship.
petition.
Yes, lordship. Tomorrow, lordship.
No, this we have brought already the fixed matters. There are lots of fixed matters are already there. May not be possible, or maybe at best, maybe by 3rd of September.
Next date is 29, lordship, in lower court, lordship.
No, that I don't know. 3rd of September.
May I please? Still want a bail application. It was listed on last 2nd of June. Therefore, it is not listing.
Bail
I have
application,
to
I
check.
make a prayer before most probably MK Kalita.
I do not want
No,
listing.
not the MK Kalita special bench to yes, no? MK Kalita special bench. Mr. Justice Kalita. Before Justice MK Kalita, you make a bench.
Hey, please, your lordship. For listing of a criminal petition, your lordship, in the first week of September, your lordship.
Maybe 5th of September.
Oblige your
Well, one pending criminal revision petition, stay order is there, matrimonial dispute, my lord. But I have filed this case, my lord, because, my lord, the authority, my lord, is not issuing, my lord, me get pass. He is a grade 4 employee because of dependency of the case. I have filed one, my lord, and let it come on, my lord, day after tomorrow. Because otherwise,
No
my lord,
possibility.
from 31 onwards,
No
he
possibility.
earlier
Maybe
mentioned,
on
my lord.
3rd of September at best. 3rd of September.
Otherwise, he may, my lord, lose your job. Only that much permission only.
3rd of September.
May I please, lordship? Lordship for listing one criminal revision petition. Any date on?
5th of September.
Wait, please, your lordship, I beg to mention listing of a criminal petition, your lordship. Last it was listed on 16/7/2025, as it was directed to be
Because
listed.
we have collected the fixed matter for this court also. We don't have any space to fix the matter, so it may be at best on
Lordship,
5th of
next
September.
week, any date will do.
5th of September.
5th of September,
Yeah.
obliged.
May also date 5th of September.
Okay. What
My
what is nature?
It's criminal petition.
My lord,
I am also praying, my lord, motion, my lord, motion Friday, my lord,
No, not possible. Maybe Monday, Monday.
Monday, 2 cases.
I'm trying for listing a criminal revision petition. So next week, it was last fixed on 23/6. Honorable did
Why
not
would
see.
you make a mention before the registry also? Because all the matters cannot be listed together, no?
It was a fixed matter.
It's not, cannot be, na?
Any day next week.
Fifth of September.
May I please, Your Lordship? Lordship, I beg to mention a criminal petition for listing. It was listed last 22/7/2025.
8th of September. 8th of September. We don't have any space. 8th of September. 8th of September, I'm saying,
Eight.
yes. Oh,
God bless.
May it please your lordship, 482 as application, my lord. My lord, the case is that the case has been charged under 109. FR was lost after 16 days. And it is a quarrel between even the informant has made accused to father, mother, aunt, elder brother, and I am the nephew. The informant is the nephew of mine. I was in Kerala. I do not know. When there was the police was searching me, my wife asked me, I came. Then I came to know the case has been charged sheeted. My lord, in this case, all the accused persons have been enlarged on bail by the Honorable High Court. I take your lordship the order, my lord. Guy,
which?
guy.
22. Earlier rejection order.
A rejection order, but other accused persons have been already been enlarged on bail, my lord. I take your page 35, my lord. Then, my lord, case has been charged sheeted under section 109, but kindly peruse the medical report, my lord. Even on
37 page number.
there is a abrasion and simple injury, my lord. Page 36, my lord, laceration, posterior with scarf, and my lord, simple injury, but opinion could not be given due to the CT scan. And after CT scan also, it has come to the reveal that the mild scalp shackling in the right parietal occipital region and simple injury. How it can be 307 or 109, my lord? So, my lord, I pray that I may be allowed to go on bail when I will appear before the trial court. I will face the trial along with my family people.
Now, see, earlier it was rejected, number one. Number two is that you may sustain simple injury, but it was on the occipital or the scalp region, I think.
Yes.
That's why
But,
most
but
probably
with all
109 is
humble,
there.
my lord, probably it will not come. It is not attempt to death, life, my lord. It is not attempt to life. That's why, my lord, I
Yes,
pray that I may be given bail, my lord.
Yes, Kaushik.
Is not there.
Or your lordship can verify this, call for the report. Scan
Let
copy
the
also can be
scan
called.
copy be called
Yes,
for,
yes, I have
because
got
it was earlier rejected.
Yes.
Maybe may not
Yes,
be
madam.
also you didn't get it. Scan copy of the-
And my name is also not there in the file.
But subsequently you got,
Yes, sir.
you are showing as an absconder.
And my lord, it will be settled between the family people. My nephew and accused made, charge sheet has been made against mother, father, aunt, elder brother. It is a quarrel for path between two houses.
Scan copy of the DCR call for distributed within it. It is the voting. It has to come from which place?
From my lord, Manipur.
Manipur, Bongaigaon. 5th of September. List. Oh,
September.
Right. Maybe.
these are all connected.
Your Lordship, item number 229, may we pass it for the timely, Your Lordship? My signature on legs, Your Lordship. Item number 229, Your Lordship. On signatures, oblige, Your Lordship.
Please, your lordship. Mr. P. Bodler is on legs. Kindly pass over for timing.
Now see, matters I don't know. At 2, I have a VC with Arunachal. bench, Itanagar bench.
Yeah.
If time permits, then only, otherwise, I don't know. Okay, for the timing, I'm keeping it on.
Obliged.
All matters cannot be taken at. None appears on call. For the petitioner. Please the matter according here, as on a date. And none appears on call. For the petitioner. Please the matter accordingly after 1 week, as on a date.
May it please your lordship. Your lordship, due to some personal difficulty, Mr. Kitaludar is not here. I'm praying the matter be adjourned for the day.
You're for the SC.
For the respondent CBI.
CPA. The consent of the other suit. And at the, sorry, with the consent of the other set, the learned counsel, they're waiting for the petitioner. Paper and item, they are allowed. Please the matter accordingly. It will be listed after 1 week as on a date.
Much obliged.
1 week as on a date will be by the minister.
May I please look? Look at 528 BNS application, my lord. For in view of my discharge application has been rejected.
Hmm?
My discharge application has been rejected. So against that, I'm before your lordship, my lord.
Discharge petition.
My lord,
To prayed for discharge.
my lord. my
Okay,
lord.
where is the order?
Now, lordship will find the order at page 72. Accused person Bablu Shah, Joydeep Mukhopadhyay, Tushar Sood, Hamid Ali, Kanak Das, I am Kanak Das, and Gulab Ravani are present. Today speaks for necessary on consideration charge. Also seen the petition number so file on behalf of the accused person Kanak Das and Hamid Ali and Gulab Ravani respectively, praying for allowing the accused person to discharge the accused person from the instant. Heard learned counsel for the accused person, also heard the learned additional PP. Peruse the entire case report, including the case diary. After hearing both sides and perusing the entire case report, including the case diary, prima facie including materials under section 120B, 420 IPC, read with section 45 of the Prices and Money Circulation Scheme Banning Act has been found against the accused person Hamid Ali, Kanak Das and Gulab Ravani, and prima facie including materials under so and so has been found against the accused person Bablu Shah, Joydeep Mukhopadhyay and Tushar Sood. Accordingly, formal charge under section so has been framed, read over and explained to the accused person Hamid Ali, Kanak Das and Gulab Ravani, and formal charge so has been framed, read over and explained to the accused person Bablu Shah, Joydeep Mukhopadhyay and Tushar Sood, to which the accused person pleaded not in the claim to be tried, issue summon to PW and for evidence. Now, till that there is no evidence still now, my lord, because in between the court has transferred and they're on leave, and no witness till now has been turned up. Next that is fixed on 15/9. Now, lordship will kindly take up page number 13, that is the FIR.
This case matter record may be controlled.
Now see, if you never go by the FIR also,
My lord, now,
that very specific order has been passed by the learned CGM.
absolutely, lord.
Everything has been considered, your material has been considered, this, I mean, your petition,
My lord,
as well as all the privacy matters, then only this charge was framed.
my lord,
So without perusing any case diary and or the case record,
absolutely, lord.
cannot,
So, first, I want to clarify what is the whether there is
you are Kanak Das.
Yes, my lord. I am not the director of the company. I am an employee. So in that regard, whether 120B, 420, read with 4 and 5 of the Prices and Money Circulation Scheme Banning Act is applicable in my, that is what my content.
That's what I'm saying. You are an employee,
My lord,
but the entire company, your involvement in the company or how the price cheats money and all this act comes
my lord,
against you
my lord.
has to be seen.
Yes, yes, my lord.
Otherwise, we cannot pass any order at this stage.
Because in the initial stage when the FIR has been lodged, my lord, It is absolutely against that all the three directors. I have seen Bablusa and other, they are the directors, and against the directors, the FIR has been lodged by the inspectors. Later, when I haven't been also been arrested, my lord, being an employee of that financial company, and later on the basis of the regular bail, I've been allowed because I am not a director and no incriminating materials have been found in the case diary. That on that basis, I have been regular bail has been granted. Later on, my lord, when the charge sheet has been submitted by the police, there I have been shown that I have issued the debenture certificate, I have taken the money, everything, which is absolutely contradictory to the statement in the rest of the witnesses has been given. And then lordship really, if you look into the charge sheet, absolutely, that is why I am before you.
Yes, Mr. Kosh.
The court may be called for otherwise, my lord. At this stage, while dealing my lord, the personal petition, you must only see the what is the illegality in the order of it. Here,
Apparently, we don't find any. We don't find any.
Yes.
That's
there is none. Either as it may.
Because it's not a case that we cannot say that the non-employee of judicial mind, etc. You cannot say because
Yes.
everything was been considered.
Yes. Because this
Apparently,
court is not a fact-finding court now.
obviously.
And only on that basis, my lord, what I have found, my lord, on the basis of their 164 statement has been given, my lord. That is also before I moved the bail application, already that 164 statement is a part of the case diary, my lord. Now, none
At
of
the time of bail application, there may be privacy
my lord.
considering your aspect that may be
Understood.
granted. I
My
don't know.
lord, my lord. Now, none of the witnesses has been stated anything.
Whatever.
My lord.
Because during investigation, definitely there are some materials on
My
the
lord.
basis of which you
Understood.
have been charged sheeted.
My lord.
So at this stage, we cannot say without appraisal of
Lord,
any
you can
record and
call
all.
for the
So we are
LCR.
calling for this scan copy of the case diary
My lord.
along with these things. And is there any number 2? Is number 2 is there?
My lord.
Private respondent is there or not?
Yes, my lord, there is.
Yes, Inspector, my lord.
Private respondent number
Who
2 is
has
there.
lost the FIR, my lord.
Who lost the FIR?
My
Are
lord.
you representing the number 2?
My lord, by name he has made party, we cannot.
By name you have made part.
Oh.
Otherwise, state could have represent.
My lord.
Actually,
But by
it was not
name-
necessary.
But I'm not. It
It
can
was not necessary. Otherwise.
You think of it, if
my
it
lord.
is necessary or not, because only official
My lord,
thank
state can,
the FIR was lost.
my lord, that can
So
replace.
on the next date, you can see.
My lord.
Hart, Mr. You are Mr.
As so, my lord.
Asher. Hart, Mr. Asher. The learned counsel for the petition and also heard Mr. R.R. Quashing. Learned additional PP appearing on behalf of state respondents. Back me up a little bit, this is an application, section so and so in connection with. For, against, against the imprint order dated 2/9/2024, whereby the prayer for teacher was rejected by the Court of Learned City. First one, issue notice to the respondent number 2. Daily and as usual process. No notice, no formal notice is required to be served on state respondent number 1. However, copy of the petition may be served during the course of the day. Next product, also call for the scan copy of the TCR along with the case. We'll see matter accordingly. After 2 weeks we'll do.
My lord, next date is 15/9. Before 15/9, any date, my lord.
Saying a date is problem, in fact, before 15/9.
My lord.
10th of.
My lord. My lord.
By
Obliged.
that time you take
My lord.
dates.
My lord. Obliged.
I seek my apology, my lord. My item is 11.
It's
Just
already over.
if
We are
possible.
listing it on after 1 week only.
The actual lordship, my lord. My lord, this is an application under section 528 for setting aside as well as for the quashing of the negotiable instrument complaint registered case number 11/2022, registered under section 138 of the NI Act, pending before the Court of Land, Additional Judicial Magistrate, Chirang. First, my lord, I just want to draw your lordship's kind attention, my lord. The check in question has not been issued to Susmita Sarkar. I would like to take your lordship to annexer. Take one second. Annexer 8, my lord, page 35. Second question was issued to Seema Sarkar, not to Susmita Sarkar, my lord. Pardon, my lord. I just want to draw your lordship's very minute attention, my lord, to para number 6, page 4, my lord. Para number 6, page 4. I'm just reading out the contents of only the relevant contents of para number 6 for a lordship's kind convenience, my lord. That the petitioner begs to submit that the brief facts of the case of the respondent are that on 11/9/2020, the petitioner had come to respondent's father's house, that is Seema Sarkar's husband's residence, and seeking financial help of an amount of rupees 5 lakh for his urgent personal need. The petitioner also assured the respondent's father, Seema Sarkar's husband, that within next 6 months he will return back the said amount to Manoranjan Sarkar. So amount was taken from Manoranjan Sarkar. And also, my lord, I just want to draw your lordship's kind attention also to page 17, my lord. Page 17, para 9. Lordship got it, my lord? Page 17, para 9. That is the NI case lost against me, my lord. On para number 9, the complainant herself has stated that the complainant grabs his right to file civil suit against the accused for recovery of the amount given by him to the accused as temporary accommodation. It is purely of civil nature. Money receipt has been given, my lord. I don't deny it. Money receipt, it is a purely of civil nature. NI Act will not be affected, my lord. In this case, my lord, I just want to draw your lordship's kind attention to the Income Tax Act. Section 269 SS. Only the relevant portion, my lord, only the relevant portion I am reading out for lordship. Your lordship will be satisfied. Section 269 SS, no person shall take or accept from any other person herein referred to as the depositor any loan or deposit or any specified sum otherwise than by an account pay check or account pay bank draft or use of electronic clearing system through a bank account. If C, the amount or the aggregate amount referred to in clause A together with the amount or the aggregate amount referred to in clause B is 20,000 rupees or more. Only 20,000 rupees can be given as a loan. Not, my lord, 5 lakhs. Not as a 5 lakhs. There's a charismatic judgment has been passed by the Honorable Kerala High Court, my lord. So
see,
I will
this
place it
will
at the time of
definitely-
hearing, my lord.
There may be income tax under which there may not be 5 lakhs checks may not be, handed over or the loan cannot be here. But your case is a bit different. You see, admittedly, you took loan.
I don't deny that.
No, yes, the check was accordingly issued.
My-
The notice was also served on you. So there may be a civil suit or their civil suit may be pending or there he
No,
may
madam,
be
not
decide,
the-
not pending, he may decide to lodge institute a civil suit also. That may be the position, but the question is that you have issued the check. Only point is that check was not issued against by Susmita, but to Seema. That may be one of the aspects. Otherwise, you have issued the
Then,
check
my lord, the NI Acts,
and the
NI
income
case-
tax act, these things
NI
will come
Act
later
is-
on.
Mother, NI case barely lost against me if I have issued the check in the name of the other person.
That's what I'm saying. You're saying
And
that
not
it's
that-
not the Seema. You have
My-
issued the check
My lord,
in
my
favor
lord,
of Seema, not
my-
against,
my-
not in
my-
favor
my-
of Sushmita.
And my lord, I also want to draw your lordship's very kind attention, my lord. I not yet take your lordship's valuable time, my lord. Annex of 10, page 41, my. This is the order passed by the Land CJM dated 10/7/2025, my lord. Only, my lord, your lordship just turn to the next page 42. I have perused the case record, and from the record, it appears that this case was fixed for judgment since 26/5/2025, but due to the absence of the accused on medical ground, case was adjourned in the last 2 days. This court directed the accused to appear before the court physically with original medical documents, but he failed. Hence, you should notice to the medical officer. My lord, I have been suffering from mental disorder, my lord. Doctor's certificate is there, my lord. Only I want, only I want,
This
my
is
lord.
fixed for judgment, in fact.
My lord, my lord.
Now you have
That is
come.
why. That is why, my lord.
That is why means.
That is
At
why, my lord,
this,
I have
at
come.
this time of judgment, you have come.
Because NI case will not lie, my lord. Because
No,
I have
live,
been-
this right, that will come later on, but at this stage of judgment only you have come.
Yes,
for
ma'am.
quashing.
I admit, ma'am.
Absolutely.
Admit, my lord. I am only, my lord, only only 1 month stay order, my lord.
Not at all.
The record.
Cannot be.
My lord, here,
Your
I am a
case is, your
psychiatric.
case is fit to be dismissed today.
My lord, I am a psychiatric patient, my
Your
lord.
case is
I'm a
fit to be
psychiatric
dismissed,
patient, my lord.
rejected today itself. It's not a case.
Only for time
At the
being.
time of
Record be
judgment,
called
you have
for-
come, this go with this. With the-
Record be
with
called
this
for, my
court.
lord.
Pardon?
Record be called for, my lord.
No, no, your case will be dismissed. Rightly, wrongly, maybe, there may be
Yes,
suspicion
my
or
lord,
something,
my lord, my
whatever.
lord, my lord.
That is different thing. Heard Mr. SS. We are on 15, SSA Rahman, the learned counsel for the petition, and also heard. No, only petition, so and so. This is an application, the section so and so, in connection with so and so. For washing of the NICR case number 11 of the 2022, registered under section 138 NI Act. Expert. It is submitted by Mr. Rama that the present case is not maintainable in its present form. No, case is not maintainable in its present form, and the check in question was issued in favor of one Seema Sarkar and not in favor of Suspita Sarkar, who instituted. Have you filed this, the complaint petition here?
My lord.
Complaint petition? Where is the complaint petition, Miss NI case?
That is, my lord, on page number 15 to 19, my lord. Annex 1, page 15, my lord.
15, 1-5. 15 to 19.
15 to 19, my lord.
No, complaint case. Complaint petition. Ah, yes, this is on page number
15, my lord.
11. It is okay. It is the last line. No, in favor of one Seema Sarkar. It's a suspicious Sarkar who instituted the NIA complaint before the learned court of CGM. Sorry, Chirag. Mr. Rahman further submitted that this is a case of civil in nature, wherein the money receipt is also issued by the husband of the accused petitioner, and the loan agreement was also executed accordingly. Further, he submitted that the party may approach the civil forum for appropriate relief, and there cannot be a case under the NI Act. Next point. After hearing the submission made by the counsel for both sides, I have also perused the case record and the annexures filed along with the petition. It is seen that on 10/7/2025, an order was passed by learned SDTM S. Chirag wherefrom it is seen that the case was already fixed for judgment on 26/5/2025. But only due to absence of the accused on medical ground, the case was adjourned. It also reveals that on 2-3 occasions, the accused was directed to appear before the learned trial court below, physically with the original medical documents, but he failed to appear and to accordingly to ascertain his medical ground, the authenticity of the medical documents. The court had already called the medical officer to be examined, fixing the date on 5/8/2025.
It was medical order.
Thus, it seems that the case is at the stage of judgment, and the present petition has been filed only at the time of judgment, which is to be passed by the learned trial court. In view of this, I do not find any ground to entertain the petition at this stage, and accordingly, the same stands rejected. Your petition stands rejected.
Highly obliged, my lord. Obliged, my lord.
Please, I beg to mention item 12 plus I am.
It is already over.
Plus,
1 week later, I have.
my name may be.
No name. It's already passed. None appears.
Due to plus a traffic
I cannot see.
date may be fixed.
We are not fixing any date after 1 week.
You
After 1 week, I have fixed the date. Registry will fix the date accordingly. Only after 1 week I have fixed.
May I please, Your Lordship. In this case, I'm challenging the FIR, Lordship. It's page number 18. I'm not the named accused person. Now, what has happened, Lordship? There is certain allegation with regard to some anomalies in the bank with regard to some purchase and selling of vehicles. Just referring to page number 18, Lordship, this is the FIR.
You have paid for quashing of the FIR.
Yes, Lordship. What has happened, Lordship? Several notices have been issued to the petitioner. I've annexed those notices, Lordship. It is starting from page number 20. I've annexed all these notices. Now, in view of those notices, Lordship, the petitioner approached the concerned trial court, Lordship, for anticipatory bail, Sessions Court, Lordship, and accordingly it has been granted. I'm just referring to the relevant portion of the particular bail, Lordship. This is a page number 26, Lordship. Page number 26, the second paragraph. Lordship, got it? Peruse the bail application and other documents and the photocopies of the documents by the annexure. Having perused the said document, it appears that the accused petitioner, namely Sri Sumit Nath, has been newly appointed as brand manager of Shriram Finance only on 3/4/2024. In the case in hand, admittedly, the informant is a police personnel and accused petitioner is not an FIR name. In view of the facts projected by the FIR of the case, direct implication of the accused petitioner in the alleged commission cannot be brought out, except the fact that the accused petitioner is the present branch manager of Shriram Finance. Hence, the accused petitioner has been able to show reasonable apprehension of his arrest in connection with the said case, and accordingly, bail was granted, Lordship. Now, what has happened, Lordship? The FIR, long back, the FIR has been lodged, Lordship, but till now, nothing has happened. That was of 2024, 2/5/2024. Nothing has happened, but repeatedly, the police is harassing the petitioner. Every time the petitioner has been summoned or called to appear before the concerned police station, Lordship. That's why, with regard to that aspect of the matter, Lordship, I filed this.
Here, only 91 notice has been sent. He is the official of a finance company. This matter relates to my lord.
This is 181.
91.
Oh, sorry,
91
91
CRPC. So what Lucas, he has to come before this court for quashing, my lord. He's apparently, my lord, he has no, his name is not there. 91 notice because he is the manager of a finance company.
Give me
So
documents. and
obviously, he's
note of
bound to produce the document.
No.
He can go and he can produce the
I can
document.
produce
my
the.
lord.
I
And
can,
he is under bail, my lord.
I can produce the document, but the fact
Because
is,
case is still under investigation, it's not a
Exactly.
case that against you any charge sheet is filed or not.
Yes.
There may not be any prima facie case against you on the basis of which you have
Lordship,
already
at
granted
this-
bail.
at this stage, Lordship,
You are on anticipatory.
exactly, Lordship. At
So
this
now
stage,
producing the documents on 91 under
no,
section,
Lordship,
how causing anything?
Lordship, what I'm submitting, Lordship, at this stage, the scan copy may be called for.
No,
No,
I am
what's
saying,
this copy? Why is this scan copy?
Lordship, with regard to the status, because repeatedly I have been asked by the, because I am,
That cannot be.
I
possible.
appeared before the-
You're not cooperating.
I am.
You are simply asked by the police officers that you
Yes, sir.
come and just show us the documents and all you got evidences just so that we can proceed with the case and all. But you are not cooperating.
No.
Because of you have obtained the anticipatory bail.
Yes, Lordship.
Because of anticipatory bail, you are just sitting in a home and without complying the
Lordship,
notice,
my.
not at all cooperating.
Yes, Lordship.
That is the case only.
In the FIR, I am not the named accused person.
Whatever, that's
Exactly.
you have granted bail already.
Exactly.
You have already granted bail. You
Yes,
are on some protection. So police station, you are going under 20, I have
But the defeat.
just, Mr. Koshik had remind me that it is under 21, okay, sorry,
91
91 only.
CRPC, yes,
91
sir.
only, not 35
No,
P and all, nothing
The
is there.
production of document only.
Production of
The
document
production of
only.
document is there, Lordship, but the apprehension of the petitioner is that, Lordship, there is every possibility that he may be implicated in the case. So at this stage, Lordship, I'm not saying, I am not saying, because it's of 2024, Lordship, for last 1 year, nothing has happened till date, Lordship. Nothing has happened till date. So
Why
at least,
since
Lordship,
now
the
you have
scan.
come before this court, I just cannot understand.
Lordship,
Now see, if you cooperate the investigation team, then definitely they can move. That means you are guilty of this offense. That's why you are suppressing all the documents and all. That is the case. You are not cooperating, you are not appearing. That means what? You are some way you are involved in this case.
No, I was.
That is the case. That's why you are
I was not
appearing.
involved, Lordship,
And
because
what
the
is
incident
apprehension?
prior to my joining of the.
That what is the
concerned
apprehension
finance
on your part?
company, Lordship.
You are already on bail, your
Exactly,
91 notice has been served. So what is the apprehension? What is your apprehension?
My,
Cannot be any apprehension. That you may not be arrested.
Three
your
occasions
colleague-
my notice has been sent.
there are,
Three times he has not cooperated.
Not
That's why
cooperate
repeated
at all.
notice are sending.
Yeah.
He can go and produce the document. He is under the
Obviously.
protection of bail, my lord.
Hmm.
If any apprehension is there.
Then obviously.
the only difficulty is that, Lordship, if I submit those documents, there is some sort of
You'll be
apprehension.
arrested or you'll
Exactly,
be
there's
implicated.
some sort of apprehension in the mind of the petitioner, Lordship. That is the reason why,
You are
Lordship,
already under.
my
protection.
limited prayer at this stage, Lordship,
No.
scan copy may be called for a date, may be
You are
fixed on the
Mr.
next date,
You are Mr. SP
after a
Chaudhary?
week.
You are
So
Mr.
that,
Chaudhary?
yes, Lordship. After a week, a date may be fixed, Lordship, in the meantime, scan copy with regard to the status of the case, Lordship. Status of the case.
But
For what purpose, my lord?
yes. Heard Mr. SP Chaudhary, the learned counsel for the petition. And also heard Mr. R.R. Kaushik, the learned additional PP appearing on behalf of state respondent. This is an application under section so-and-so in connection with so-and-so for quashing of the FIR registered under Likhiti Bana. That's so. It is submitted by Mr. Chaudhary that the present accused petitioner is innocent and he is no way involved in the alleged offense. And considering all these aspects of the case, he was already granted anticipatory bail by the learned court of, which court he had granted bail? Learned court of
Lordship,
sessions,
session judge, Lordship.
learned court of session judge,
Kachar.
Achar section. But in spite of obtaining the pre-arrest bail, the police officer, the investigating officer is harassing the present petitioner by issuing notice one after another. And accordingly, the present petitioner has the apprehension that he may be charged in connection with this case. Mr. Chaudhary accordingly prayed that the case diary may be called for and that it may be perused. This involvement of the present petition. Next para, Mr. Kaushik, the learned additional PP submitted in this regard that present petition is not at all maintainable because as the petitioner was served it only notices the section 91 BNSS, but it is 91 BNS or CRPC?
CRPC.
Yes, what CRPC? 91 CRPC only for production of the some documents or evidence. But without complying those notices and without cooperating the investigation, the present petition has been filed for seeking the quashing of the entire affair. Next, hearing this submission made by learning counsel for both sides, I have also perused the case record and the annexures filed along with the petition. It reveals that the petitioner was granted bail, considering the fact that he is not involved, considering the prime facie materials, and accordingly he was allowed to remain on the privilege of pre-arrest bail. He being the director, he was the company employee director or what?
Is the branch manager.
Branch
Lordship.
manager.
Branch
He
manager.
being the branch manager, the company, branch manager, the notices was issued on him under section 91 CRPC only for production of some documents and also to get some evidence. But without complying those notices, The present petition has been filed for praying for quashing of the FIR against the present petition. In view of this, I do not find any justified reason to proceed with the case further, and accordingly, the present petition is hereby stands rejected at this stage. Your petition stands rejected.
Yes, Your Lordship. Always.
May it please your lords. My lord, application under section 528 of Bharatiya Nagarik Suraksha Sanhita. The prayer for quashing of FIR, my lord.
On a POCSO case.
The POCSO case, my lord.
It's a POCSO.
POCSO case.
You have come from quashing for POCSO.
My lord.
You have come for quashing in POCSO.
Yes, my-
Section 6 POCSO.
May I please? Is a application for quashing of the FIR lawsuit. Before perusing the FIR lawsuit, I would like to peruse the agreement between this party. There is a page 15 lawsuit between the informant and this petitioner lawsuit. It's a pure in civil in nature lawsuit. Case is pure in civil in nature. Kindly page 15 lawsuit. This is para. May I read the para relevant portion? The agreement for sale of land is executed by the first party along with the second party, as the name of the second party is in the land record of the scheduled land, and the third party, Srimati Priyanki Malik, she is the informant, has agreed to purchase 1 katha 5 plesa land at the rate of 4,50,000 per katha, in total consideration 5,62,000, out of which rupees 150,000 has been paid to the first party. Here, first party is the petitioner. That is Prabhat Patter. Now, she has informant has lodged the FIR. This FIR is page 14. First page, page 14. This is page 15. This is page 14. It is mentioned here that she has paid 5,75,000 as an advance amount, and other 450 amounts has been yet to paid by the petitioner, and petitioner has already begged the money 1,25,000 to her, because this agreement has been not operative. As this is the case, Lordship. It is a pure in civil in nature. Informant.
No, informant is the landowner.
No, petitioner is the landowner.
Petitioner.
Petitioner has made an agreement with the informant.
Yes.
She has agreed total amount of 562 lakhs rupees, and informant has paid 1,50,000 to the petitioner in 2020. Now this agreement has been cancelled due to some reasons, and this petitioner has already paid back to her 1,25,000. It is stated in the FIR lawsuit itself. Now she has give me pressure that another 4,50,000 rupees I have to pay to her. This why he has lost these affairs. It is clearly in civil in nature, and I have in agreement. That's why I have produced the agreement. I have paid only 1,50,000 in agreement. She said that I have to pay 4,50,000 to her. This is the case. There is a civil forum. You can go to the civil forum for money shoot, and all documents is here. This agreement is unregistered documents here. This is origin copy is page 17. In her signature, both the parties have signed. And petitioner name has been muted in the year of 2021. And this agreement, no date has been mentioned in the agreement. But I guess that it is this was executed in 2020 because there is another person, Dulab Soikia. Originally, he was the owner. That's why it's a purely civil in nature. That police has pressured me many times, come to my house to pay the amount to her. This is the case.
It seems civil nature, but my lord, can you peruse the agreement?
Yes,
Page
agreement
18,
is there.
Page 18,
Page 17 and 18.
second paragraph. Those my learned friend skip.
No, I'm not excused.
My lord, you are supposed to give 50% within 1 month. So, my lord, by doing this, my lord, he has taken the money. So, my lord, there is a transfer of, my lord, there is a, my lord, promise that you do this, I will pay. He paid, my lord, but after that, silent. There is an element of criminality here.
Lordship, 50%,
Handing over of properties there.
50% have to paid by the informant to me. But that at that time, I have applied for the sale permission and I have requested her to pay their remaining part. She has not paid. Can you read properly? উল্লেখ থাকিল যে আজিৰ পৰা এমাহৰ ভিতৰত বাকী থকা টকাৰ 50% তৃতীয় পক্ষ বৰাবক দিয়াৰ পাছত বৰাবৰে তৃতীয় পক্ষৰ সৈতে মিলি মাটিৰ প্ৰয়োজনীয় নথিপত্ৰ দি কেঁচা বিনাৰ অনুমতি উলিওৱা হ'ব। But I have already
Definitely.
this
it
is
seems
just purely
that,
civil
it
nature.
is, civil in nature, but
Yes, yes.
the case is still under investigation. So we are calling for the case diet.
Yes,
You are on bail, I think.
No, this is all are bailable section laws. This is
All are bailable.
bailable 319, 316, 296, and 3.
316 is also bailable.
316 also, subsection 1 is the bailable law. Criminal breach
bailable?
of trust. This is a definition. Subsection
Definition
1.
is otherwise, whether it's a bailable.
Bailable, yeah.
316 is also bailable.
316, subsection 1. Bailable, yeah.
319 is there, that is not bailable.
That is also bailable. 319, subsection 2. That is also bailable.
Therefore,
I have gone through the sections. And it- 316, that is the definition of criminal breach of trust. They have wrongly put the section 6. Yes.
it's not, cannot be bailable. It's the 3161 is the not the 3162 is the penal section, I think.
Yes.
Penal is 316 of 2. It's wrongly.
Prohibit- In chart, prohibited source, like it is a bailable. 316.
Bailable. Can't be bailable.
Not bailable, my lord, 5 years.
Yes, 5 years.
5 years, but it's bailable. Lordship. I have gone through the telephone from it. It's bailable. Yes, yes, Your Honor.
No, 316 cannot be
I,
bailable. It's a cheaper, cannot be bailable.
no, I have not carried that book. So,
316 and subsection 1 and 319 subsection 1, these are the only the definition under which the cheating and impersonation is comes.
Yes.
And 2 is the penal provision. So 3192, if you go by 3192, it's 5 years. And 3162 is also 5 years. So it's a not bail.
319.
That's why I'm asking whether there is any, you have obtained any bail.
319 is
Just confirm it. Because
subsection.
we are going to call for the, can copy, I mean, the case diary. Otherwise. Heard Mr. G. Pukan, the Learned Counsel for the petition, and also heard Mr. R. Kaushik, the Learned Additional VP, appearing on behalf of state as a sergeant. Since this is an application of the section so and so, connection period is so and so, for quashing of the FIR, dated 5/7/2025, registered under Roha Police Station, case registered as Roha Police Station case number 75 of 2025, corresponding to GR number 1489 of 2025, under section 319 subsection 2, 316 subsection 1, and 3296 of the 3 subsection 5 of BNS. It is submitted by Mr. Fukon that the present, the FIR, the plain reading of the FIR, it seems that cases of civil in nature and wherein the agreement for sale was executed between the parties. And the parties can approach the civil forum for it. Next, Mr. Kaushik also submitted in Mr. Kaushik, the Learned Additional PP also submitted that prima facie, it seems that case is of civil in nature, but from the agreement, it reveals that the petitioner had reached the agreement for reached the reached the condition of the agreement for sale. Next paper, hearing this submission made by attorney counsel for both sides. It seems that cases of civil in nature. However, to know the actual fact of the case, let the case diary be called for. Fixing, yes, be calling for the case diary.
Scan copy. ma'am. Yes, there is.
Call for this case diary. It can be. It has to, it is cases of from which place?
Roha Lordship.
Noga.
Roha.
Roha Noga. Pehले, I can pray for state investigation that this is.
No, state investigation. cannot start. 8 of September. 8 of September. 8. देखिए this speaks for you. Now let it go to classification also. 9 of September. 9.
Hello.
Yes.
Lordship, this is a criminal petition filed under section 520 of PMSS against the order dated 17th July 2025. 17th July 2025.
Achha.
As by learned special judicial magistrate Kamrun Metro. In CR case number 1121 of 2015. By
What was the order? Order is it
yes. Order is yet case number 51.
50?
51.
50.
May I please your lordship? This is at the stage of motion. We need some time to fight the client, to deal with the matter.
Otherwise, what was the order in fact? Order
That
was-
is against the framing of charges. They have come for quashing of the framing of charges.
Oh,
Their
achha.
contention is that they have already settled the loan amount of the IDBI. So no case is made out. But the concern is that there is a criminal liability. For that purpose, this CBI has filed the charge sheet. So their plea is that we have settled the loan. But with regard to the document which are forged and filed in the IDBI bank and they have obtained the loan about 1 crore. So criminal liability will remain there because the complainant is IDBI bank. So if anything is required by the IDBI bank by way of compromising with the complainant or withdrawal of the complainant, then it can be exonerated criminal liability. Otherwise, it has been given to the CBI for investigation. A number of documents are there which are forged. And after forging the document, they have obtained the loan from the IDBI. So at this stage, if
But as per their plea is that the loan amount has already been settled as per them.
Yes, as per them. So the framing of charges itself is error in order.
As per
But the
them.
criminal, as per them, but the criminal liability will remain there. So in that event, they can argue there, they can try there, they can give their evidence, defense evidence to that effect. But at this stage, this court cannot go for mini trial. Now, prima facie, there is an offense. We may be given time to deal with, if at all, or at this stage, it can be dismissed.
Lordship, the petitioner runs a company. The petitioner number 1 is the one of the board of directors of the company, and petitioner number 2 is the company. Lordship, in the year 2009, the petitioner took a loan for growing his business from IDBI Bank. Lordship,
Now
the loan.
that's
Yes,
she has also admitted
yes.
that the question is that most probably the loan amount has already been settled.
Already been settled.
So that may be one of the ground for
Lordship,
you
in the
for the
absence of-
quashing. But they said that there are this thing, but criminal liability was there and holding some documents he obtained a loan. That was the main concern.
Yes.
So on that basis, charge may be framed, but yes, obviously, they may be allowed to some time to give their objection. And in the meantime, we may also call for the scan copy of this.
Scan copy of this.
Let us see.
Lordship, can an interim stay till the next date be given because there are multiple cases against the petitioners.
Multiple cases.
Multiple cases regarding
Yeah,
the
like
same
we did,
matter. Regarding the same matter, one PMLA case is also pending by the ED, where the wife of the petitioner number 1 was also dragged, but she was discharged by the learned specialist Kamuk Metro, specialist Assam on 37 July 2024. Your Lordship.
So you are saying that there are multiple cases have been pending.
No, not
against-
multiple cases regarding the same matter. Your
Then
Lordship,
now
one was
see what
CRT.
is your case. That means
There is a serious offense.
Regarding the same
it's
matter.
against
Your
you that you
Lordship.
have committed similar kind of offense repeatedly by forging
No,
documents.
no,
and you're
regarding the
obtaining the
same
loan.
loan. Regarding the
That is
same
there only. It seems.
loan could not be paid because of loss of my business, Lordship. The account became non-profit.
Okay, regarding stay, do you want to have submit anything?
Thank you, Lordship.
Till next day, if it can be stayed, but the stay will be against.
Stay may not be granted at this stage. It is at the motion stage. And moreover, section 19C of the 19(3)(c) does not allow to permit any stay
Yes.
in the proceeding
Hmm.
because it has to be completed within 2 years, maximum 4 years. If there is any stay, then the matter will again delay. So let there be a reply by the CBI. At this stage, stay cannot be granted, Your Lordship.
Okay.
PCA
Your MSS
Jet high.
Jet Hyatt
3C is there in the PCA.
PCA. PCA. PCA.
Yes, 93C. 3C. No court shall stay the proceeding under this act on any other ground, and no court shall exercise the power of revision in relation to any interlocutory order passed in any inquiry, trial, appeal, or other proceeding.
But charge is framed under which section?
Yes, I'm coming to that. Your Lordship.
Charge is framed under which section? Ujjal Kumar Das is 120. You are Mr.
Ujjal Kumar Das.
You are Ujjal Kumar. So against him 120
120B,
B
420,
and 420.
467, 468, and 471 of IPC.
467, 468 is also there. So
Yeah.
at this stage, it is very
No, what I'm saying, PC under PC.
under PC.
No. Under PC Act, it's not been framed at. No? Charge.
Charge is not
Charges
framed at
under
PC.
the IPC, Your Lordship.
It's only IPC only.
Yes.
IPC. And he's a private person.
By the within next date, you can file your submission, then we may
Yeah.
heard here. Hard MSS Jet Hyatt, the learned counsel for the petition, and also hard MS M Kumari, the learned standing counsel CBI. This is an application, the section so and so, in connection with so and so court against the order of framing charge dated 17/7/2025. Issue notice to the respondent. No formal notice, absolutely no formal notice is required to be served on the state respondent NCP as has already been appeared. However, copy of the petition may be served during the course of the day, if not already furnished. Next product, MS Hyatt submitted further that case has been already settled between the parties and loan amount has already been already been liquidified, and hence there cannot be any further proceeding and matter has already been set. So, but without considering this aspect, case has the charge has already been framed against the present petitioner. In that context, MSM Command, the Learned Standing Council, CBI, submitted that there may be settlement, but there are criminality is there in the case itself. And the loan was also obtained by forging some documents. And accordingly, she submitted that some time may be given while their written objection in connection with this case. In view of this, let the scanned copy of the DCR be called for. And the matter may be listed after 2 weeks will do, after 2 weeks, enabling the respondent to file their written objection if any. Listed. Okay, it will be listed after 2 weeks.
Much appreciated. Yes.
May it please your lordship.
Yes.
Lordship, 528 quashing application. Lordship, seeking the quashing of 2 impugned orders, primarily the first impugned order only because the second one is a consequential order, my lord. So, lordship, what had happened, the respondent number 2, my lord, even though this is a 528 application, and with regard to some procedural irregularities that come before this court, it is not mandatory to make the informant a party now, my lord, as per the notification. However, my lord, I've made a party, the respondent and the earlier informant, because it's a complaint case now, as because of Naraji petition. The party may come and notice may be directed to be issued today. However, lordship, I seek a few minutes of lordship's indulgence because I have a prayer for stay, my lord, on the point of procedural irregularity and, my lord, complete overlooking of the direction of the apex court as well as this high court. 2 judgments, my lord, 2 lines, my lord, those I'll place. So what had happened, my lord, the respondent number 2, informant and subsequently complainant, he had lodged an FIR back in the year 2017, my lord. Their FIR is at page number 24, my lord. This is a 2017 FIR. Against the 2 petitioners, my lord, the petitioner number 1 is a major in the Indian Army. He was posted in Tezpur at that point of time in 2017. Presently, he is in Army Headquarters, Delhi, my lord. Petitioner number 2, my lord, is his wife. May I read the relevant part of the FIR, my lord? That the above stated Sri Partha Borua, son of Pradeep Borua of house number 9, this place, is an officer of the Indian Armed Forces, and as a result of an advertisement published in the month of December 2014 for different posts at CWE Tezpur, we came in contact with Major Partha Borua along with his wife Judy Borua, promised and assured us to provide government job in different posts and thereby induced us to deliver amount from the undersigned Pradeep Chamwa to deliver sum of rupees 10 lakh. This is the first allegation. Delivered sum of rupees 10 lakh on different dates in the name of different persons, payment made to others, to provide jobs to my 2 sons, Rondeep Chamwa and Pragyan Chamwa. And finally paid rupees 10 lakh, same thing, on different dates to Major Partha and his wife, who delivered 2 numbers of fake appointment letters. Second allegation, my lord. In the name of the above stated sons from me, the undersigned and Sri Milan Jyoti Borua to deliver a sum of rupees 3,25,000 on different dates to provide job at CWE Tezpur. So, my lord, the allegations are that the informant's son's job, they will secure the present petitioners, and they took rupees 10 lakh and they provided 2 fake appointment letters, and one another person by the name of Milan Jyoti Borua was also induced to pay 3,25,000. So, these 3 aspects. Now, my lord, police investigated the matter, and my lord, finally, a final report was submitted, my lord. That is at page number 26, the type copy. If lordship comes to page number 27, my lord, the last part, after a few dots are there at page number 27, my lord. On the other hand, the complainant gave the money in the year 2015 and filed the FIR in 2017. No evidences were found against the accused of taking money. So, through WT messages, again asked for the FIR name accused, Partha Borua and Judy Borua, asked to cooperate investigation. No evidences were found to implicate the accused in this case. So, for the lack of sufficient evidences, this final form is submitted against the Partha Borua and Judy Borua. They are the petitioners. So, FR submitted. Now, on the FR being submitted, my lord, the court very correctly issued notice to the informant. The informant filed a Naraji petition. Naraji petition, my lord, would find at page number 31. Here, my lord, the same thing in the FIR, but he has elaborated as to 10 lakh only. The allegation is that he paid us rupees 10 lakh. But here the elaboration is that 10 lakh, one day he took out 40,000 from ATM, one day he took out 40,000 from his home. So the elaboration of the earlier allegation that this amount of 10 lakh was taken by the petitioners. Second allegation is also there, my lord. Same identical allegation that 2 fake appointment letters were issued to his sons. And third allegation is also there, my lord, that this Milanjyoti Borua was also induced by us to pay rupees 3,25,000. So basically, he is not satisfied with and he can rightly be not satisfied with the investigating agency. He has the right to do so. And he put this complaint petition. What is, I beg your lordship to notice that the allegations that 10 lakh, 2 fake appointment letters, and 3,25,000. Now, my lord, we come to the first impugned order, my lord, by which this CR case was initiated. That is at page number 42, lordship. It's a very contradictory and cryptic order, my lord. May I read, my lord? Page 42. So on receipt of this complaint or Naraji petition, this order was passed by perusing the final report submitted by police, the case diary, and this Naraji petition. The informant Pradip Sharma is present along with learned counsel. The informant has filed petition number this is the Naraji petition 3172, to submit objection to the acceptance of final report submitted by the investigating officer. I have perused the case record and the case diary. Upon perusal of the case record, it appears that the investigating officer submitted the final report in this case registered under 420, 468, 406 of the IPC, stating that there was lack of evidence regarding the allegations made by the informant against the accused person. On perusal of the case diary, this is the pivotal part and my case is dependent upon this, my lord. The perusal of the case diary, it seems that during investigation, no prima facie material with respect to the alleged offences was found to be established against the accused petitioner. As such, the case diary does not disclose any material irregularity for rejecting the final report. Considering the observation above, the final report is accepted. So this is a judicial order, my lord. Case diary is perused, final report is perused, and it is accepted. First part of the order ends. Now the learned trial court, my lord, comes to the Naraji petition. The petitioner, informant by petition number this, has prayed for registering the complaint case to allow the informant to proceed with this matter before this court already. The Honorable High Court in Criminal Revision petition number 38 of 2013 has stated this in qua non for taking cognizance of an offence that the complaint or protest petition must make an offence which constitute an offence as defined under 2D of the CRPC. On perusal of the instant petition, it seems it fulfills the essentials of a complaint. I agree to that, my lord. Accordingly, register the instant petition as a complaint case and let the same be placed before the CJM Sunitpur for necessary action. So, my lord, exact identical facts, the learned trial court is stating that the FR is acceptable. Lordship, the petitioners cannot interfere or involve themselves whether to FR to be accepted or not. Had the FR not been accepted and sent for further investigation, I would have had no say. Because but the exact same three things, 10 lakh, no appointment letters, and 3 lakh. He has accepted the final report, and the same exact allegations, my lord, he has started the CR case. Now, on receipt of a Naraji petition, a magistrate court can very well, under section 190, take cognizance, start my lord, proceedings of a CR case. But, my lord, not so when the facts are absolutely identical, my lord. Because a matter has happened from our High Court only coincidentally, my lord, that under these circumstances, the CJM from Silchar has rejected that no, this complaint petition is on the same materials and facts. CJM Silchar has rejected. Then, my lord, the complainant had gone to the Sessions Court. Sessions had reversed the decision. So, no, CJM, you registered this as a CR case. That was registered. The, my lord, accused persons came before this High Court, my lord, by a revision petition. This High Court also, my lord, allowed the order of the Sessions Court. That is, no, the CJM was wrong. That is on same material facts also, even if it is there, register it as a complaint case. The, my lord, accused persons went to the Apex Court. Last year's judgment, my lord, 24 SSC online 3126, clear and unambiguous words that no. My lord, our High Court's verdict as well as the Sessions Court verdicts were reversed. That if it's on the same materials, my lord, then it cannot be entertained. Maybe you go back to the order, maybe you order a further investigation. Those things can be discussed on a case-to-case basis. But this, my lord, clearly barred, my lords. My lord, just do the judgment. And another aspect, my lord, where the learned trial
But
court
listen,
possibly
but
has
the
a.
question is that by 4/10/2023 order,
Yes, my lord.
okay, there is one part I also do agree that acceptance is there.
Yes, my
But
lord.
it's subsequent, if you see that it was, the cognizance was not taken.
No, my lord, cognizance has been taken, my lord. Not
By-
by that order, but subsequently. My lord, the second impugned order at page number 44. Now cognizance has been taken. Summons has been issued to me to my Guwahati address. I am residing at Delhi.
No, cognizance has been taken after recording 202, I think.
After, yes, my lord, that procedure has been followed. But my lord, that complaint case 836, my lord, the genesis, it has to come into existence. So if its existence is flawed, and today, my lord, this trial proceeds, and tomorrow this court comes to conclude that the very inception is incorrect, my lord, then it is judicial time and it would amount to abuse of process of law. So in my limited understanding, my lord, as of now, my lord, as of now, because the next date is day after tomorrow, and even though it is not a compelling ground, my lord, the petitioner number 2 has undergone breast cancer surgery. Those documents are there. Day after tomorrow, with a nurse, I come and appear. And tomorrow, this court reaches a conclusion that the very initiation of the case was not tenable in law, my lord. My lord, then it would be abuse of process of law. So I humbly pray that, my lord, I may be allowed to issue notice and this may be stayed until next day. Let the informant also come. There will be no irreparable damage to the informant if it is stayed for one date, my lord. Because, my lord, only if lordship pleases, my lord, this judicial time I'm using up, my lord. My lord, if we go through, my lord, only 2 paragraphs, my lord, on same facts and same materials, the complaint petition or Narazi petition cannot and should not be entertained, my lord. My lord, last year Supreme Court has settled it in very clear words. And, my lord, the 2013 order, which the learned magistrate quotes, my lord, only one aspect is very correct, my lord. This Narazi petition fulfills the condition of a complaint. Because at times what happens, there are no names on list of witnesses. So this does not comply with 2D. To that aspect only, he has gone through this, my lord, judgment of Honorable Justice Bhaipe, my lord. But here also, my lord, it was actually rejected only, the Naraji petition. If your lordship just goes to paragraph 12 of this judgment, which the learned trial court, my lord, either failed to go through or, my lord, overlooked it, my lord, this was also dismissed. Consequently, if your lordship goes to the final paragraph. Only one thing the trial court took into satisfaction is that 2D conditions are fulfilled. My lord, I'll issue notice, let it also come, my lord, until next day, my lord. The proceedings may be stayed because this is a procedural irregularity, my lord. And under 141 of the Constitution, we are bound by the Subrata Chaudhary judgment last year, my lord. That much I pray, my lord.
Range is concerned, my lord, it satisfies that has been, my lord, settled, my lord. It satisfies the, my lord, mandate of what has been.
2D, my lord. Yes, my lord.
required
That I am
under
only
the
submitting,
complaint
my lord.
petition, my lord, along with the witnesses. And as the lordship has pointed out, after 202, my lord, the cognizance has been taken, my lord, after examining the witnesses, my lord. That will not be, my lord, the materials in the city will not be, my lord, as far with the, my lord, the statement of the witnesses, man. That is a separate process. There is that can be, my lord, done, my lord, because as per the complaint, my lord, that proceeding can be, my lord, initiated, my lord, subject to what the cognizance with three cognizance, my lord, procedure has been followed, my lord. That has been followed here.
My lord, what my learned friend is saying, my lord, that I am not debating that it does not qualify the nature of the petition. But what about the fact that, my lord, that the same materials and same allegation, if it comes in the form of a CR case, my lord, every time the accused cannot be vexed. Underlying that legal maximum principle, if lordship goes through only 2 lines of paragraph 32 of Subrata Chaudhary's judgment, my lord. Last page, very last page, paragraph 32, my lord. Very last page, the 4th line, very last page. May I read, my lord? Thereafter, finding that both the complaints were identical, the finding of the High Court that the second complaint was maintainable was rejected, and the subject complaint was dismissed as not being maintainable. In the case at hand, a perusal of the protest petition dated 5/5/2011 and the second complaint dated 2017 would reveal that the second complaint filed after acceptance of final report filed pursuant to investigation FIR based on complaint this. And that too after considering the Naraji petition and hearing the complainant, the second respondent herein, the second complaint dated this has been filed reproducing the first complaint dated this and stating that the said complaint was not properly investigated. Here also is stated FIR not in, and action should be taken on the second complaint dated this. In fact, the indubitable position is that the core of the original complaint dated this and the second complaint dated is the same. In the light of the decision of Ravindra Singh and Samta Naidu's case, repeated complaint by frustrated litigants cannot be maintained. A scanning of the second complaint dated this would reveal that none of the situations permissible in terms of the decisions referred supra exist in the case at hand to maintain the said complaint. When that is the position, the learned session judge as well as High Court were not justified in interfering with the order passed by the CJM, this by which the Naraji petition was rejected, my lord, holding that second complaint as not maintainable in law using further direction. And if your lordship goes to the first paragraph, my lord, the fact is stated identical to our case at hand, my lord. So, my lord, no irreparable damage would be caused, my lord. But against me, my lord, it might turn out to be an abuse of process of law or maybe judicial time of the trial court also, my lord. So let this matter be sorted, my lord. In the interest of justice.
The learned counsel for the petitioner. And also heard Mr. MP Goswami, the learned petitioner. Senior advocate ইয়াৰ পৰা কাম কৰিব Mr. MP Goswami, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so for your quashing of the entire case or CR overlooked the SCC online SC 3126. Letter of Nangita Likidibo, Subroto Chaudhary, LIS Swelso versus State of Assam Swelso. Next para, Mr. Goswami, the learned additional PP submitted in this way. That the order of 4/10/2023 is rightly passed, wherein it was also observed by the learned court below. Observed by learned court below that para page number 43, the line is inverted comma line is mark to it, page number 43. So yes. More so, the cognizance was taken by the learned trial court below only after recording the statement of the complainant and the witnesses under section 200. It's the case against the present petitioner pending before the court of learned so and so. The state till next date of this. Also call for the scan copy of this petition is the matter accordingly after. Also, you have to take steps.
I'll have to take steps upon respondent number 2.
Notice respond number 2. Issue notice on respond number 2 accordingly. After 2 weeks.
Deeply obliged.
Yeah. Is
Document-
9 all connected or?
all analogous. Lordship may take up item number 7 along with the item number 2 because they are
7 and 2.
7 and 2 arising out of the same judgment. Lordship. What happened in this case, Lordship? The matter relates to NI. Now, trial court passed an impugned judgment, and both the informant and the accused both preferred a revision against the judgment. Complainant preferred a revision against the judgment, saying that no compensation was allowed, and compensation equivalent to the check amount was only imposed as a fine. And accused has challenged the order, preferring an appeal. In the appeal, Lordship, the trial appellate court, the additional session judge took up both the matters, sitting as an appellate court also, as a revision also. in the appellate judgment, without any modification, accepted the trial court judgment and dismissed the appeal. In the revision, the same court, same judgment, modified the judgment and imposed 2 lakhs as compensation by the same court on the same day. While taking up the appeal, without modification, accepted the judgment of the trial court, and while taking up the revision on the same date, same judge, modified the order, saying that the imposition of imposed 2 lakhs as compensation. In all these
So
cases, there are 4
appeal filed by the accused.
accused. That was dismissed and we preferred revision. And secondly, there is a bar
Appeal filed by the accused.
accused
Which
that was
dismissed without any modification alteration.
lost,
And in revision filed by the complainant, it was
modified by the same judge on the same day against the same judgment.
And 2 lakhs were given as a compensation.
Compensation.
Okay.
Lordship, otherwise also, there is a bar under section 401 of subsection 4 of section 401 of CRPC. When appeal lies, no revision can prefer. But there was a provision under section 372. If victim is agreed with the judgment, she can prefer appeal. He or she can prefer appeal. Instead of preferring an appeal, the complainant prefer a revision petition. So that is a bar under subsection 4 of section 401 of CRPC. So without jurisdiction, that revision was filed and that was accepted and modified the judgment. Now, Lordship, all these matters are arising out of same complaint. Facts and circumstances of the all the complaint is same. There is a arbitrum in all the complaint because as per the allegation of the complainant, that accused was a contractor and he received some work order. And it was agreed between by and between them that the complainant will supply the materials and accused will execute the work. And the profit out of the execution of the work, they will share the profit a 60-40 ratio. But in the cross-examination, I will take your Lordship to the cross-examination. There was no settlement of account. But as a security, the accused handed over some checks and he, without settlement of this account, and there is no proof that work has been executed or completed and the accused has received the bills amount and all these things without any sort of settlement, he has placed those checks and he has dishonored the check. So there is no, absolutely there is no liability. He has failed to prove the liability. So at this stage, Lordship, I pay that judgment and orders suspended. I am ready to pay the minimum 20% of the check amount as which was as a compensation, which was
No, while admitting your appeal and all that time, 20% was there, question of 20%.
appeal, Lordship, no. I did not pay any
So
amount.
was there any order for payment of this 20%?
No, there is no such order.
No, just tell us in item number 2.
3 and 5 are arising out of 7. 2 and 7 is same. 3 and 5, 4 and 9, and 6 and 11.
So now you are before this court against your appeal, na? Order
Appeal
of
also,
appeal.
again, I prepared an appeal against the revision against the appellate order and also against revision order. Because complainant filed a revision, I have to challenge that order also because in that order, I am directed to pay compensation of rupees 2 lakhs. I had to
So
get
you have
a
challenged that revision order also.
also. Item number 7 is the revision against revision, but not by the same party. And item number 2 is the revision against appellate order.
Just a second. Item number 7 is the revision against.
Against revision. Revision was filed by complainant, and against that order, I had filed a revision.
So this revision is against the revision filed by the complainant.
Complainant, not.
And in item 2, it's an appeal against revision against appeal.
Yes.
So in item number 2, is the order of appeal?
Lordship, I have an page 66. Annexure 3. Operative part, Lordship will find at page 77 at para 34. May I read, Lordship? The sentence impose a fine of rupees 8 lakhs with 6 months simple imprisonment in default is not excessive or disproportionate in the facts and circumstances of the case. The compensation order to be paid to the complainant is equivalent to the check amount and hence within the confines of law. In view of the above discussion and finding, the criminal appeal number was stand dismissed. Now, in the revision, Lordship will find the revision order as item number 7.
Sixty. 60. Your order is on 60, 62. Huh?
Lordship.
Just I want to say, while admitting your appeal, is there any 20% situation was there? No,
No,
it was admitted.
it was admitted, hard, and disposed of.
Now you are ready to pay 20%.
20%.
This is an application section 20 in connection against a judgment and asking criminal appeal number whereby the appeal was dismissed and the order was in 9 days number Kibasi is up. Order submitted before the same court, the complainant also instituted and revision claiming the compensation along with the compensation amount wherein the revision was allowed and the present appellant is present petitioner is directed to pay rupees 2 lakhs as a compensation.
Not लिखित हो जाए रिविजन अगेंस्ट रिविजन तो होटल में चेक नहीं होगा सर्विस में किस टाइप लगेगा
Issue notice to the respond to register the organization process. Also call for the scan copy of scan copy. Also call for the record of এটা আছে না এটা ফোন কৰিব এটা তলৰ কোৰ্টৰ অৰ্ডাৰ এটা এনআই 2 নম্বৰ ৰেকৰ্ডটো হৈছে সেশন কেছৰ এপিলৰ অৰ্ডাৰ এপিল 3 নম্বৰ ৰেকৰ্ডটো হৈছে ৰিভিজন তিনটা অৰ্ডাৰ So at this stage, against you, whether any warrant etc.
No.
was issued?
No.
Not yet. The order of appeal was passed or dated?
36/2025.
6. The execution of order dated so and so, passed in criminal appeal number so and so, state subject to payment of 20% of the check amount.
I'm still on bail. I may be allowed to remain on previous bail.
It was 148, I think.
148.
148. And section 148 again. Further, the petitioner is hereby allowed to remain on previous bail till disposal of the connected, the disposal of the present. The 20% of the check amount will be paid within, how many you need?
2 months.
2 months is within 4 weeks.
4 weeks.
Within 4 weeks. Before the registry you want to? Or
Without
this
trial court,
trial
was it?
court, yes. Within 4 weeks, and the amount will be paid before the termination, which will be accepted by List the matter accordingly after 4 weeks. List the matter accordingly after, yes, it's after 4 weeks. It will say item number 2. Item number 7 for definitely same থাকিব. But this is the revision against revision. Submission is passed with criminal revision petition same থাকিব. আৰু issue notice কৰি দিব খালি comfort scan. Revision number 2 আনিব. Revision of order date 2 আনিব. আৰু ইয়াৰ increase will be listed or further revision or further proceeding or so revision also there will be further proceeding. 2 lakhs was there, na order of
Yeah.
stake.
There may not be any
No,
condition for payment of
no.
20%.
Yes. So we state that one the
Not-
payment of 2 lakhs. State the revision order with expense to state till next up to list of 4. So instead of listing on can not like it. Okay. And 4 weeks post. And what about 3, 4, 5?
3,
Yes, 3. What is 3?
3 and 5 are another.
3 and 5.
3 and 5. 4. Lordship may take up the 5 past, it is revision against appeal. And 3 is revision against revision.
5 is
Revision against appeal,
5 is same order. 5 is revision against appeal.
Lordship. And 3 is revision against revision.
And 3 is revision against revision.
Revision.
বাকি order যেনেকে revision against appeal. Similarly, seconds to revision against revision আছে ইয়াতে 3 revision against revision and 5 to revision against appeal. আৰু এইকেইটা side of and ইয়াতো 20% subject to payment of 20% under section 148 of before so and so same order. That will be in item number 5. 5 or 2 lakhs. Oh, sorry, no, no, sorry, 20%. Okay. আৰু 7 to 20%. It will be 20%, আৰু বাকি 3 and 7 there will be stay same order. মানে to কৈছে তো 3 to appeal, 7 to revision against appeal, 3 to again revision against revision, and 5 to revision against appeal. A revision against appeal 20%. And what about 4 and 6?
4 and 9, Lordship. 4 and 9 are the analogous method.
4 and 9.
9. Lordship may take up 9 first. 9 is the revision against appeal.
9 is the revision against
Appeal.
appeal.
And 4 is the revision against revision.
4 is the revision against revision. 9 is the revision against.
6 or 3 lakhs.
In all the matters, 2 lakhs as
No,
a
no.
compensation is given, or how many?
3 lakhs in item number 2 lakhs. 2 and 7, 2 lakhs, it is 3 lakhs.
No, 7
3
equals 2 lakhs.
2 lakhs. And
And 3, how many? 3.
it is 3 and 5, 3 lakhs. 3 lakhs. Sorry, if you are talking 4 and
Tell us in 3.
3 lakhs.
3. 3, how many?
3 lakhs.
Amount? 3 lakhs.
Compensation 3 lakhs. Check amount was different. So
No, it's different. In number. Our আগতে
four,
next revision of the application. 3 number of 3 lakhs.
4 9.
3 lakhs. আৰু
1.
5 penalty, so 5 appeal. Bit of it. And 4 is revision against revision. 9 revision against appeal. 9 or revision against appeal of 20%. Or 4 or revision against revision. Where is the number of in revision 4?
4 1
What
lakh.
was the amount?
1 lakh. Compensation 1 lakh.
Same order, 4 or 9 of 1 lakh. Revision of that.
Okay.
1 lakh.
6 and 8 are 1 lakh.
I don't know. 6 to do. 6, where is the order of revision? Three lakh. Not 1 lakh, 3 lakh.
3 lakh.
No. In item number,
6.
item number 6.
6 3 lakh.
6 is revision against revision.
Revision against
Revision against
Well,
appeal. 6 is
revision against appeal.
No, 6 is revision against appeal.
Lordship.
8 is revision against
6 is revision against appeal. And 8 is revision against revision.
Revision.
administration.
So in item number 6, you have annexed both the orders. I
Yes,
believe.
sir.
So where is the revision order here? Is it
Revi-
page number?
Item number
9.
8.
8 8. 8 1 8 2. Item number 8, Lordship will find at page 64. 1 lakh was imposed as a compensation. Yes,
1 lakh.
1 lakh. 6 or 8. I think.
It's kind of order. খালি মিলাই মিলাই এনালাইজ কৰি এটা অৰ্ডাৰতে জবাব দিব সেকশন বা টেকনিক্যাল সাইডস ৰেকৰ্ড সাইড দাও এটা অ্যাপিল এগেইনস্ট অ্যাপিল আছে সো 20% দিব 8 is revision against revision na
Revision.
and 8 is along analogous with 6
With 6.
6 to appeal 6 or 20% করে দিবা the same order this stuff for this okay
Deep level.
that out of the demo compliance order will also produce the compliance order.
May please.
20% be deposited asset after depositing the 20% of the petition is hereby asked to produce the compliance or the order of compliance. Image.
May it please your lordship. The petitioner has filed this revision petition challenging the final order dated 30/7/2025 passed by the learned Principal Judge Family Court Barpeta, directing the petitioner to pay monthly maintenance of rupees 7,000 as well as rupees 2,000 for the proceedings, lordship. At this stage, notice may go, lordship. An scan copy of the LCR may be called for, lordship.
Part Mr. P. Body and the Learned Counsel for Education. This is an application under section 438, read with section 442 PNA. Against the final order dated 30/07/2025, passed by Principal Judge Family Court, Barpeta, in FC criminal case number C, packet of criminal, case number 20 of 2024, directing the petitioner to pay maintenance at the rate of rupees 7,000 per month in response from the date of filing of the petition, with a further direction to pay rupees 2 lakhs at the cost. Issue notice on the response number 2, registered hearing. As usual process, also call for the scan for the petition. Please remember after 3 weeks.
3 weeks, lordship. Any date, lordship.
After
Lordship.
date you want.
Lordship.
After 3 weeks, any date. Seventeenth of September.
Lordship, there is a small submission, lordship. In this case, what is to be decided, lordship, whether the parties have filed their assets and liabilities as mandated by Rajnish and Neha case, lordship. So-
We let the respondent be appear,
Lordship,
and if you both the parties agree, suppose, then
Lordship.
you may pass a direction for that only.
lordship, then
Yes.
lordship, a simple observation may be made, lordship. The prayer for interim may be considered on the receipt of the LCR, lordship. That will suffice because
Now see, this kind of thing, generally I don't pass any order on interim. Let us see.
Lordship.
Let them appear.
lordship,
17th.
oblige your lordship. May it please your lordship.
Before this vote, it will be on. It on. No, fix corridor. Dispose for. এই বড়ুয়া তুমি একটা কই কথা আপনি strictly legal. Yes,
My please, your lordship. This is a regular
so
bail.
here we have received any CD case.
My lord, case are received.
This is a regular bail application, lordship. As on the behind the bar, lordship, 34 days, lordship.
34
Petitioner,
days.
34 days, lordship. FIR page number, lordship, 20, lordship. May I read, lordship?
Yes.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে আমাৰ লগতে মুঠ 48টা গোটৰ আত্মসহায়ক গোটৰ আইডি নাম্বাৰ আৰু গোটৰ নাম ব্যৱহাৰ কৰি জালিয়াতিৰে ষ্টেট বেংক আৰু পাঞ্জাৱ নেশ্যনেল বেংকত ভুৱা একাউণ্ট ব্যৱহাৰ কৰি লক্ষাধিক টকা আত্মসাৎ আমাৰ অজ্ঞাতে আত্মসাৎ কৰে, গতিকে বিষয়টোৰ ওপৰত উচিত তদন্ত বুলি আহ্বান জনালোঁ, লৰ্ডশ্বিপ। This is a totally false and fabricated FIR, lordship. I am not a FIR name, lordship. In this case, lordship, I am just working as a bank mitre, lordship. I am never generated any ID number, lordship. I am never authority to sanction any bank loan, lordship. In this case, lordship. And lordship, after receipt of the said Ezaha, lordship, after receipt of the said Ezaha, after lost by the said Ezaha, lordship, I inquiry into the matter, lordship. Many of the groups have the ID number, lordship. Few of the group have no ID number, but they are all our members and groups are genuine, lordship. They are before file of loan application, lordship, before SRLM office, lordship. SRLM office prepared a forwarding letter and they put the ID number, lordship. And secretary and president of the SHG group, lordship, they receive of the forwarding letter, lordship, then submit the concerned bank, lordship. Then concerned bank, lordship, verify all the document, members of the document and PAN card, Aadhaar card, voter ID, etc. Lordship. Then if the concerned bank authority is satisfied, then the bank sanctioning the loan lordship to the SHG group lordship. And more than, I am working as a bank meter since 2022 lordship. More than 100 of groups are get loan lordship. All the groups are genuine. All the groups are genuine. All the groups are recovery. They are pay loan amount, recover their loan EMI lordship regularly lordship. If it is emulated is their lordship, then bank authority lost FIR against me lordship. But behind the bar lordship 34 days lordship, kindly consider. Also, forwarding letter is revealed that all the documents were seized by the investigating officer lordship. It is based on document based on lordship. Lordship, kindly consider.
My lord, first thing, my lord, this is not a regular, my lord, for bail matters, my lord. Bench for regular bail matters, and it is not rejected by your lordship earlier.
That's what I'm just inquiring with Mr. Burwa also,
My lord.
why this case is before us.
Yes.
One matter is disposed and it is here written on AB was disposed by me, in fact. Most probably out of same FIR. That's why I don't know. That may be one of the reasons why
Yes.
it is here.
That's why, my lord.
Maybe.
Maybe.
That's what I'm just asking
That's-
Mr.
I'm
Burwa
just
that why
mentioning
this
that.
case is here
Okay,
before this
because-
court, and he
Yes.
show me that one disposed matter is there. Really, that may be the reason. I don't know. That may be the reason. Anyway,
But in this case, my lord, only this petitioner is arrested, my lord, and there is so many persons involved, my lord. Because, my lord, against this person, my lord, there are 48 FIRs. 48 FIRs. And, my lord, all the subject matter of all the FIRs, my lord, are same. That lady, my lord, collected all the documents from the, my lord, village woman, my lord, and they deposited where deposited, my lord, the petitioner knows, and, my lord, ultimately
he collected the documents.
my lord.
What you said, he collected the document.
Yes, they collected the document, my lord. This is every, my lord, the statement are several statements are here, my lord, and, my lord, there are 4 lakhs against each, my lord, self-help group, my lord, 4 lakhs sanction, but they are not getting that 4 lakhs, my lord. They are not getting that particular these 48 numbers of, my lord, self-help group. They are not getting. They are getting that 4 lakhs. That is embezzle. And, my lord, in every, my lord, statement, here is the, my lord, the name of the present petitioner, and, my lord, he is the prime accused in this case. He is the prime accused. And, my lord, police recovered, police seized, my lord, some of the documents, my lord, that regarding, my lord, their KYC document, my lord. But yet, my lord, because, my lord, it is a 48 numbers of, my lord, self-help groups. Lots of, my lord, paper yet to be verified. And, my lord, another thing, that those women are, my lord, from the village, my lord, my lord, very common people, my lord. My lord, if at this stage, my lord, she will get bail, my lord. So there are, my lord, sons of, my lord, hampering and tampering the, my lord, evidence. That is, my lord, very good chance is there, my lord. So, my lord, at this stage, my lord, only 34 days, my lord, it is a huge, my lord, financial offense, my lord, economic offense, my lord. So, how, my lord, one lady, my lord, not only he, my lord, some bank official also may be, my lord, involved with that. So, my lord, only one person, that petitioner is only, my lord, arrested in this case, apprehended in this case. There are so many investigation is on, my lord, and investigation is at this stage, my lord, very nascent stage. So at this stage, my lord, I am opposing the grant of bail, because, my lord, the investigation will suffer, my lord. At this stage, my lord, she will get bail.
When the police, lordship, when the police produced before the Chief Judicial Magistrate Dhemaji lordship, police taking custody lordship, 3 days custody lordship. SP Dhemaji lordship, additional SP, officer in charge Dhemaji police, so all the officers interrogated me. I am fully cooperative lordship. All the groups are genuine, but some few groups have no ID number, but their documents, their HSG group are genuine lordship, genuine lordship, and it is based on document based lordship. I have no sanctioning authority. I am just bank meet lordship. I am just fill up there. I am a sitting in bank lordship. I am a help desk. I am fill up just document lordship. if it is emularized, they are all prepared by the asylum office, forwarding letter prepared by asylum office. Now, I am in this matter, lordship, I am not a FIR name accused, lordship. Later on, lordship, I am working as a lordship, the district secretary of BJP, lordship, Kisan Morcha, lordship. In this, according to petitioner, lordship, Kishor Mukti Hongram Committee, lordship, Kishor Mukti Hongram Committee spread some rumors against me, lordship. I am used the ID number and bank number, lordship. If it is anomalous is there, lordship, then must bank loss FIR against me, lordship. All the groups are regularly pay their EMI, loan EMI, lordship. Nothing is there, lordship. This is
But
my
as
humble.
per the
My lord,
agreement, those group has not received the loan amount. For each self-help group, there was 4 lakhs were sanctioned. But as per allegation, they have
Yes.
not received
Lordship,
those.
it is based on document basis, lordship, based on already documents are seized, lordship. I am behind the bars 34 days, lordship. Kindly consider, lordship. I am fully cooperate. Police interrogated me 3 days, lordship. I am fully cooperate with the investigation, lordship.
My
I am
lord-
just bank method, lordship. That's
My
why
lord,
I
I
am
am-
received per
my
day
lord-
rupees 50 rupees, lordship. I am just per day rupees 50 rupees, lordship. It's a political rivalry, lordship. That's why Kishor Mukti Hongram Committee, lordship, lost the FIR. Second FIR is the Kishor Mukti Hongram Committee. They are more created this situation, lordship.
My lord,
In
I am
this-
reading just one statement, my lord, one statement.
So, see, this is the application, regular application, lordship. Kindly consider.
মই মিলি জুলি SHG সদস্য আমি 10জনী মহিলা মিলি বেংকৰ লোন লৈ চলি আছো আমি বেংকৰ পৰা দুবাৰকৈ লোন লওঁ এইবাৰ লাষ্ট লোনৰ কিস্তি লৈ থাকোঁতে আমাৰ গোটৰ নাম আৰু ID ব্যৱহাৰ কৰি কিছুমান মহিলাই লোন লোৱা বুলি NRM LM অফিচৰ পৰা ফোন কৰি জনায় পিছত আমি NRLM অফিচত যাৱাৰ জানিব পাৰো যে কল্পনা চেতিয়া বাইদেৱে আমাৰ গোটৰ নাম লৈ লোন লৈছে বাইদেৱে আমাৰ গোটৰ পৰা 4 লাখ টকা লোন উঠাই লৈছে আমাৰ গোটৰ নামত তাইৰ উচিত শাস্তি হ'ব লাগে
Lordship,
This kind of statements are there.
ID number is prepared by asylum office, lordship.
Part Mr. D. Chutia, the learned. You are Mr. D. Chutia.
This would be, lordship.
Part Mr. D. Chutia, the learned counsel for the petition. And also heard Mr. P. Sharma, the learned additional people appearing on behalf of Justice Warrant. This is an application of Swenson in connection with Swenson. CD received, parents received. It is submitted by Mr. Chutia that present accused petitioner is innocent and she is no way connected in the arrest office. She is working, discharging her duty only as a bank patron, and thus she is helping some self-help group in filling up some form and all. And that effort, she is not connected with the arrest office. Furtherly, she submitted that she is not generating any ID, not authorized by the bank officials to grant loan and run for more so. The bank generally grants loan only after verifying the documents and all the self-help group who have paid for loan are also found to be genuine and accordingly the loans were sanctioned in the name of the self-help group. Apart from the helping those self-help group in obtaining the loan, the present petitioner has no role as a bank patron. No role, and as a bank patron, she is honestly discharging her duty. She further submitted that accused petitioner is in custody since the 34 days, and thus I was sufficient opportunity to interrogate the present petition, keeping her in custody. And hence, further custodial interrogation may not be required for the interest of the investigation. Mr. Sharma, the learned petitioner, raised payment objection, submitted that the present accused petitioner is the prime accused in the alleged offense, and she is the person who, by means of fraud, obtained loan in the name of the self-help group, and each group had and in the name of each group, rupees 4 lakhs were sanctioned, but none of the groups have received the loan amount. Thus, she misappropriated the entire amount of money. Further, he submitted that 48 numbers of FIRs has been pending, are being pending against the present petitioner, and the the investigation still in the nascent states, and the other culprits who may be involved in the arrest offense are yet to be named. Mr. Sharma further submitted that the accused petitioner being the woman from the same locality, there is every chance of tampering with the investigation if she is granted with bail. Next, para, hearing the submission made by learning counsel for both sides, I have also placed a case record, case diary, and it reveals that the IR has calculated sufficient activity matrix against the present accused petition, and considering the nature of allegation and stage of investigation, and that further custodial interrogation may be required for the rest of the investigation. In the same time, the probability of tampering with the investigation also cannot be denied at this stage. In view of this, I do not find it fit to extend privilege of bail to the present petition accordingly. Same stands. Your petition stands at this stage. Rejected.
Lordship, kindly taken up the matter after 10 days, Lordship.
Huh?
Matter may be taken up, Lordship, after 10 days.
10 days means
No,
it is
after-
already rejected. Okay.
Highly obliged.
28, 29. May I please, Your Lordship?
Yes.
Both the bail application, item number 28 is the second bail application, my Lordship.
28.
Yes. And 29 is a first bail application. My Lordship may be aware of this case, my Lordship. Yes, sir. The
Right.
co-accused has been enlarged on bail. 302,
Yes. 302, ma'am.
302 matter, my Lordship.
So
My
who
lord,
is
in
your
this
present
case,
petition?
in this case, my lord, is there not received?
Huh?
28,
What is
29.
it? Scan copy everything.
Or scan copy is there.
It is already charged sheeted case, I think.
Yes, yes,
Yes,
my
yes.
Lordship. Charge sheet case, ma'am.
In the cause list, my lord, no mention. Actually, that's why, my lord, we have not checked it.
Now, as per the allegation, there is a very sensitive case of murder, in fact, wherein some of the petitioners have already granted bail.
Already granted.
And
Out of five,
your petitioner is two. How many petitioners?
all total 5 co-accused are there. Out of 5 accused, 3 has been enlarged on bail.
These two are remaining.
These 2 are there. Here,
So what is
here,
the stage of the case at present?
it's the evidence stage, ma'am.
How many evidence it was? Is there?
Not
any
yet.
record?
Not even one.
Not
ma'am.
yet record.
Out of 50 listed witness, not even one witness has been examined. Here, my Lordship, in the both bail application, I am taking the plea of non-furnishing the ground. Ground of arrest, my Lordship. My Lordship, it find,
Just a second. Sharma, have you gone through the?
My lord, I have.
You only need some because he was not aware about the
Yes.
of this record.
My lord, Kali fix, my lord. Tomorrow or day after tomorrow. my lord. Check.
Tomorrow I could.
Yeah. इनको भी पहले मैंने कहा था।
tomorrow.
No, no. On Friday. Okay. Day after tomorrow.
He is saying tomorrow and day after tomorrow list is already over. There are many matters are there. So may not be possible. Maybe on Monday. Will it be okay for you Monday?
Yes, my Lord.
By that time you go through the record.
My
because
lord,
as I have understood, this is a case, charge sheeted case.
My lord.
A girl was being murdered.
Hmm.
So 3 of the accused persons may be enlarged on bail, but
I'm not on the
who are
merit of the
considered
case,
to
my
be,
Lordship.
The main or prime accused. I don't know. Maybe if it's submit. So there one of 28 earlier bail application was earlier rejected.
My.
But don't know how many days they are now here in custody.
Item number 28, 312 days. That is more than 10 months. One is, and the second one is more than 7 months. 29.
Okay, then you just.
I'm not
asking-
on the merit of the case, I'm on a procedural that says non-furnishing of ground, section 50, 51A, now 47, 48. On that I am.
Okay, you can submit on that. Mr. Sharma, he
Mal-
is basically emphasizing on non-punishing
My lord, the death ground also.
ground of arrest. So you see under what pretext, under what circumstances they were arrested, whether in that circumstance it can be considered that they were very much aware about the grounds of arrest. In
Yes.
that case, there may be a
Yes,
other,
now,
or
yes.
if they were arrested subsequently, or they may not be aware of that may be another ground for ground of arrest. So see all these two.
Mal-
points. Okay, we're listing it on Monday. Monday is
Yes,
the tareekh?
none.
1st of September. Okay, 1st of September. The request made for the run additional PPTC met.
Leaders, it's pre-arrest bail, second bail. First was simply dismissed has been done with liberty to file fresh one leading to present bail application. In this matter, Lordship had directed to bring the CD.
Yes, yes, sir, it is.
It is not a charge sheeted case.
No, Lordship. I am pre-arrest bail. In this matter, I am pre-arrest bail. Two of the accused persons have already been regular bail. One is interim pre-arrest bail as per my information. The remaining 3-4 others. I can't say what is position, my lord, and may tell.
So anyway, you are not on interim.
No.
Yes, what is your case?
Lordship, my case is irrespective of the facts, there are procedural fault. As per the Lalita Kumari judgment, first, if cognizable information you receive, first you register FIR, then investigate. In my case, it has not been followed. On 20th June, they have received the information, Izhar was filed. Then they started investigation. Recovery was made on 20th. FIR was registered on next day, 21st. So this is
Then
the
recovery was on
20th June 2025. As per seizure number,
2006.
Lordship, 20 June 2025. Seizure
Recovery
as-
was there.
Yes.
And FIR was launched
Next day, 21st,
21st day of June.
Lordship. So as per that judgment, the procedure has not been followed. In fact, it appears that FIR has been lodged in order to maintain the recovery, because they have maintained the recovery first. This is my first point, Lordship. Second point.
So you are saying there's a procedural
Lordship.
irregularity.
Now, second point, Lordship, what they have recovered, wheels of some vehicle, but the vehicle in question has the different wheel. I have properly inquired. This wheel has a measure of 1100 by 20. What they have recovered?
11?
1100 by 20. This is the measurement. As per seizure memo, they have written itself. But the wheel in question, which was alleged to be stolen, was, as per the status, as per the research, 1000 by 20. There is a difference. It is a wheel of some other vehicle, what they are producing. And they have recovered one more registration book.
And recovered was 1100.
Lordship.
1100 by 20.
By 20. There is a serious difference. They have recovered, they have seized my registration book also. There is also no mention of this vehicle. In fact, it is my case that it has not scraped in my shop, not at all. And the information, Lordship, if I read the certain lines from the FIR, it appears it's planted. May you kindly see the page 26. Second paragraph. With utmost, Lordship, have got it? With utmost respect, I informed that the above named Mubarak Rahman on January 25 at Salki, Bosti near Lidu Begum, left the said vehicle due to engine problem. Lordship, what happened? The complainant entered into agreement with Mr. Mukabir Rahman and handed over vehicle to this person. After some time, in January 2024, he left the vehicle unattended at Salki Bosti near Lidu Begum. After more than 1 year and a half, 1 year and 6 months, the incident happened, this incident, in June 2025. What was happening last 1.5 years? First, second, this Mubarak Rahman, who is genesis of the route, has not been mentioned in FIR. He has not complained against this person. why he attended, where he attended, what happened to this person, and what is the source of information, Lordship. May kindly see 3-4 lines from the bottom, this page. Therefore, I went to that place along with mechanic and tried our best to repair the vehicle, but we were unable to repair it. Thus, enough time has passed. Today, that is 2025, I went to that place for the purpose of bringing down the vehicle. Lordship, may kindly just have a part. He has tried his best to the mechanic to repair it, and it was in hilly station, hilly area, to get it back, but failed. Then thereafter, he alone went there with the purpose to get it down. How it is possible? If mechanic is failed, you are not a technical person, you have no crane, nothing. How you can bring down the vehicle if it is not in running position? Thereafter, Lordship, but did not found the vehicle that place. Therefore, I inquired with the neighbors.
No, who said that he was not with? the
Complainant,
crane?
which is
No. Who said that he was not with the crane and all? Because you tried to first of all, the vehicle could not be repaired.
Lordship.
Then he came back.
Correct.
And then he, with the intention that he thought that it should be bring down. So who, from where you are saying that he, without anything, how he can bring down the case record? I
Lordship,
mean, the
Lordship,
vehicle.
as per
Is there any
what is written?
mention?
No, what is written? I am just reading only the FIR, nothing else.
No,
What?
but did not found, yes.
Yes, did not found. Thereafter, Lordship,
Ah.
that place, thereafter I inquired with the neighbors about the same, and then I came to know that residents
Oh,
are
this is a translated copy you are reading?
translated
It's a
copy.
half.
Lord.
নাই দেখো না,
Page 25, not 27,
পুরা না।
26.
It's what found that. কি বলতে পারে? Your FIR is not complete.
Page 26.
With an additional affidavit, you filed a fresh.
Okay, this page is not here. This is missing there. I am so sorry, this 26 page is missing.
Page is missing.
One page is missing.
You file in the complete FIR, translated copy of the FIR.
Vernacular is there, ma'am.
No, whatever, you complete this. You can retain the case diary.
My lord.
They will hardly take you to, I mean, your petition. Everything. You are Mr. M. Nirola?
Anilendra Pandey.
Anilendra Pandey.
Pandey.
Heard Mr. A. Pandey, the learned counsel for a petition. Also heard Mr. B. Sharma, the learned additional PP appearing on behalf of city receipt. However, on at the time of hearing the petition, seems that the translated copy of the FIR is not complete. In view of this, the petitioner is hereby directed to furnish the complete translated copy of the FIR with an additional. Till next date of listing, city be retained. When you can file.
Lordship, next 2-3 days? 2-3 days I will file. We kindly have next Thursday if possible.
Immediately after filing of the additional affidavit, then if you can by 2-3 days, then it will be listed accordingly. Immediately after filing of the addition. But can you retain the case diary because we do not.
Yes, my lord, for
For
few days it is okay, my lord.
Can be, na?
But because my lord investigation.
If convenient, Lordship, I have it next Thursday.
May fix a date, my lord, because he is coming from outside.
Next Thursday would be convenient.
Next Thursday. Next Thursday, ki date? 4th. 4th of September?
4th of Great.
Wait, please, Your Lordship. So I'm sorry, Lordship, I'm causing inconvenience. Item 24, admission matter, Lordship. I am appearing for the wife and my learned friend is appearing for the husband, Lordship.
I'm
I
for
have
the
filed-
petitioner.
I have filed another transfer petition that is 55 of 2025. There is an stay also, Lordship, the restitution proceeding. We are just praying, Lordship may send it to mediation, Lordship, if possible. They are
Yes, but
willing.
this is a matrimonial matter, so there's a chances of reconciliation.
I'm making this mention, Lordship, as one item is fixed at 2 PM, Lordship. So, pardon? I have another matter in port 18 at 2 PM, Lordship. So I'm making this.
Okay. Yes. You are appealing for the petitioner.
I am for the petitioner, item
Madam
22.
is speech.
Here, my lord, in 20th, on 30th, the date is fixed for WS. If WS is filed, my lord, there may be any problem. So till the mediation is over, my lord, proceeding.
No,
may be
that
stayed.
order cannot be passed.
Already at the
Address-
time of issuance of notice, no interim was granted. They can file lordship WS.
You can file your WS, but
Because
even
interim
after
order is
WS
not-
and all, there cannot be, I don't think there will be any part. So, and now there is a special drive for mediation also.
Yes.
So, rather we want to send the matter as many as we can it's possible. So we are
Then,
sending
yes, we can.
mediation.
for
If you
date
want
also.
any date, then
Yes.
we'll
Yes,
fix a date for appearance before the mediation. Okay. And you, I mean, inform your the petitioner as well as respondent accordingly so that they can. RMS as we should be
Mediation.
MSR Chaudhary, the learned respondent. It is submitted jointly by both the councils that the parties are interested to settle the matter amicably. In view of this, this court is of opinion that the matter
order is
be sent for mediation. And matter may be sent for mediation. To stop accordingly, both the parties are hereby directed to appear before the mediation. Mediation center, and the mediator will be accordingly appointed or be nominated by the Legal Services Cooperative. This
Today is 27.
Your matter is on 30th is fixed.
30th.
But before 30th, it may not be possible. So if you want to file your WS and all, let it be. WS may be fine. It's okay. We may fix it by 1st of September at best. 1st of September.
Monday, lordship.
1st of September is a Monday, I think.
Yes, lordship. Only 3 days. Within 3 days, mediation may not be possible, lordship.
No, you are just asked to appear before the mediation.
Yes.
There may be a sitting, two,
Yes.
3 sittings, then only on 1st of September.
Offline.
24, I don't know. All right.
অপরাধ করিব বুলি পিছলৈ আহিছে পিছে নাই নহয় আমি কৰি প্ৰব্লেম আমি এতিয়া তেওঁলোক দিছিলে এতিয়া তেওঁলোক কিমান তাতে বহি আছে এতিয়া তেওঁলোকক মই তাৰ পৰা বেছি পৰা নাই এতিয়া
মই এতিয়া ইয়াতে কৰিম
তেওঁলোক
তাতে কানেক্ট
তাতে কানেক্ট হ'ব তেওঁলোকে কৈছে আমি ৱাকলত আমাৰ ফাইল কৰাই নাই তেওঁলোকে মানে আজিহে জাষ্ট
My lord.
Yes, on the last occasion, we have heard you, Mr. Tagum.
Yes, my lord. And CD was called for, my lord. Last TC was called for, my lord.
Yeah, TC was called for.
Yes, my lord. Because, my lord, the age of now, my lord, till the filing
my
of
lord,
this
before my learned friend starts his argument, my lord, we have just come to know about this particular bail application, and we objected by way of criminal petition, where your honorable lordship was pleased to set aside. So I may be allowed to implead, intervene. We'll be filing an application. I got the instruction. So at least 1 week time may be given so that I can file my counter as well as my wakalana, everything. I'm
So
seeking only for 1 week time.
Mr. Tagum, your petitioner is in custody since when now?
My lord, since
I'm the
17
informant. I'm the
my lord,
informant. This is
17 June 2025, my lord. 17 June, my lord. As per
After the said order, you surrendered.
yes, my lord. As per my lord's order, I surrendered, my lord. And after having surrendered, my lord,
As of today, how many witnesses have been examined? Is there any?
my lord, the latest, I don't know, my lord, but as on date of filing of this present application, my lord, 14 witnesses were already examined, including they are stated to be an eyewitness. They're all examined, my lord. Only remaining part is the official witnesses, my lord. That is the rank of the officer, inspector, and deputy SP, my lord.
Yes. Okay, Mr. Singh, you want to submit, you have not submitted your wakalatnama also?
No, I just got the instruction today, my lord. I just got the instruction the matter is listed. We didn't have any knowledge. We would like to file my wakalatnama. Please give me 1 week time only. I'll 1 week time.
Okay, 1 week time?
Yes, your lordship. We don't have any issue on that, your lordship.
Okay. then.
Lordship can fix next week so that I can do the needful thing.
Okay. Heard Mr. T. Takum, the learned counsel for the petition. Also heard Mr. E. Ete, the learned additional PP, appearing on behalf of state respondent. And Mr. M. G. Singh, who entered into evidence on behalf of the informant. And it is submitted that he needs at least 1 week time to file their Kalaktama and as well as the written objection. Scanned copy of the TCR has already been received. Considering expert, considering this submission made by London Council for the Legal Counsel, Mr. Singh, let the matter be listed.
4th September month.
Pilot,
We have a matter on 3rd of September from the Itanagar bench. So can it
My
be
lord.
on 3rd of September?
Yes, my lord. Yes, my lord.
Pilot third, can it be on August 3rd? Monday? Can it be on 8th of September? 8. Because 5, 6 is my mom's Shraddha. So I have to go to Imphal. So can it be on 8? I can come on 7th. Only for the ritual, I'm going to Imphal on 5th.
Yes,
Okay,
Mr.
on 8. 8 of September.
Yes, Mr.
Now
Takum.
that we can understand, my lord. This can be done after 3 also. We are fixing the matter on 3, my lord. If it is 3, 3 will be, my lord, it will be okay, my lord. Since my lord has already fixed the matters, other matter of pertaining to Itanagar bench on 3rd of September, my lord. So after attending the start of September, my friend he can go to Ampel.
Yeah, I'll appear physically before Itanagar bench in that case. When Lordship visits Itanagar, that can be done if that is happening on 8. Otherwise, it can be through.
That we cannot say this because roster is yet to be there.
Yes, yes, ma'am.
As
So,
for my
next week,
friend's version.
whether on 8th of September I'll be there in Itanagar, that is, I cannot say, but if you, so if you are here at the principal seat, it may be heard physically you from this principal seat, or if my outcome bench is there, then you can come physically before the
8 of September.
It's okay.
Oblige me.
The question is, you want to fix it on 8th of September?
My lord.
It's my lord, I pray if my lord, if my friend, if he's do not have a problem, because he will be living a 7 only. In that case, my lord, can be fixed for on 3rd September, my lord.
I have no issue. If that is 3rd, I have no issue.
3rd September, you don't have any issue. Isn't it?
3rd is okay. Only 4th, 5th,
We can
I'll
fix
have
it
some
on 3rd
problem.
because 3rd also we have another matter from Itanagar on 3rd.
Yes.
So let
Yes,
it be 3rd of September. You can file your objection.
I'll file my Wakalam before that.
3rd of September. Okay, we're fixing it on 3rd of September.
My lord.
Now we are new code. Tagum?
Yes, my lord. Yes, my lord. Yes, my lord. New code, my lord. My lord.
Okay, okay.
Yeah.
Otherwise, everything is good. And I think it's quite.
Yes, my lord.
Yeah. I'm interested to come there within the next.
Well, wish to see you, my lord.
Sure. Okay. Okay.
Oblige.
Oblige, my lord.
May I please, Your Lordship? The challenge has been made against the charges so framed by the learned Juvenile Justice Board, Kamrup Metro. Respondent number 2, my lord.
Yes, respondent number 2 is there. 2 names, the respondents are there.
So far the name appearing in the cause list, my lord, I Hussein and Ya Ahmed. They are not appearing, my lord.
They are not appearing.
They are not appearing. The respondent number 2, counsel of the respondent number 2 are not appearing. Respondent number 2 is the complainant, my lord.
So, PP is here appearing. So here two advocates, name of two advocates are there, but they are not appearing. And one, as per order dated 12/8/2024, one legible scan copy was called for from PRC JJB. This case is related with the JJB also.
JJB, my lord. Scan copy was called for, my lord.
Have you gone through, Mr. Kusam?
Complaint, so I thought, my lord, their presence will be necessary regarding complaint case. It is a complaint, my lord.
It's a complaint.
Yes.
Not, my lord. Subsequently, it has been registered as PRC case, my lord, the police report, on police report case. And search sheet has been laid. Trial is also going on as per search sheet. But now the complainant, respondent number 2 is the just informant.
So you are basically challenging the order.
Charges. Basically challenging the charges framed by the Juvenile Justice Board and the entire proceeding, for quashing entire proceeding.
But it is a revision petition.
My lord.
There will be, my lord,
Read with section
who
482.
my challenge, first, my lord, challenge has to be, my lord, whether he is challenging the juvenility issue, my lord. That is one part, my lord. Then again, my lord, charge is also, my lord, another part, my lord. First, we have to decide if he is challenging the juvenility, my lord. We have to decide on that, my lord.
That part has been already decided by the learned judicial magistrate first class.
No,
Regarding juvenility.
His petitioner is a juvenile.
My lord. At the relevant point of time, he was juvenile.
Yeah.
And that has been decided by the learned juvenile, learned
This
magistrate.
matter is also pending before the JJB.
Now, matter is pending before the learned judge.
Considering your petitioner as a juvenile.
My lord.
Then what is the issue, Gusam?
Now, my lord, say regarding, if we go by page 30, my lord, that is the impugned order, lordship may kindly see that. This discharge petition for discharge was rejected, my lord.
This was petition.
Page 30, my lord. That is the impugned order.
So prayer, you are challenging the prayer for discharge.
My lord.
Yes, prayer
Your
rejected, my lord.
rejection.
Rejection of discharge petition.
It's a one part, and then other.
That is perhaps the only.
Then other is entire proceeding under section 482. Entire proceeding. May I submit the brief of the case, my lord?
With a legible scan copy.
Legible scan copy. It's legible.
So we go for it then, my lord. Perhaps,
Is there any stay of
Stay, my lord. There is stay, my lord.
Your petitioner now at present stage, I mean, presently he is 32 years.
Presently 32 years.
Anyway, relevant time of incident, he was a juvenile.
He was a juvenile, 16 years and 9 months. And that part has,
That aspect has gone, I think.
that
That
has,
aspect
aspect has gone.
Because
Yes.
he is considered to be juvenile and
Considered
he is
to be
planning
juvenile.
for JGB.
Yes, ma'am.
That part has gone.
Yes.
Uh, Made by scan, no, I will not scan copy of the, no, legible scan copy of the TCI has already been seen. Let the matter be. It will be after 1 week will you?
Yes. Yes.
But we cannot fix any date after 1 week.
Yes.
Because there are many dates that
Yes.
it is fixed after 1 week as in a date we fix the date.
Also, my lord,
But,
regarding,
if a date is fixed,
also regarding my lord, appearance of phone number 2, ma'am, that may also be recorded.
But it seems that so the names of 2 advocates are infected in the cause list, but none of the advocates have appeared for the response, and response number 2 remain unanswered.
one more thing here, my lordship, despite there being an stay order, the learned JJB is asking for appearance of the petitioner on each and every date, that is once in a month.
Maybe some specific order may be there that I don't.
Until
but-
further order
but
is
the
there,
case
until
is
further
stayed.
order.
Case is stayed and evidence is not proceeded.
My lord.
That is there. I don't know. There may be with the context of this JJB Act itself.
Yes, my lord. Evidence is stopped.
Pardon, evidence is stopped. Then maybe we will see to it.
Okay.
My lord, before I go to the others, the effect of the matters, my lord, may I draw your, my lord, attention on the order which was passed on 6/5/2024.
By this court?
Yes. And the second part of the order, Mr. Sharma, learned counsel for the petitioner from that, my lord.
So stay is operating.
Yes, here, my lord, the order was, the operation of the order was stayed, my lord. And before the communication of that order, the alleged nuisance was removed from this place, my lord.
Already removed.
Already removed. So, my lord, my humble prayer is that, my lord, this matter may be disposed of and it may be sent back to the DC. And my only prayer is that I want to get an opportunity of hearing, my lord. I want to file the so-called, because this order was passed without giving any so-cause notice to me. So I didn't get any opportunity, my lord. My case is that the land upon which my possession was removed, my lord, it belongs to me. So I want to file my so-cause. I want to show that I own this land, my lord. So that much opportunity should be given to me, and the matter may be sent back to the DC to decide it afresh, my lord. Already which has been removed, my lord. I am not on that. And the order which was, my lord, here impugned, my lord, the order was that Annexure D, Annexure E, page 23.
So in person to that order, you have already removed the whatever.
Yes,
50.
my home fencing was there. It has been removed, my lord. And for removal, I was never given any show cause notice, only on the basis of a commissioner's report that I have got some excess land. So on the basis of that report, my fencing was removed. So I want that some opportunity should be given to me. I want to place my show cause. Let there be hearing. And then the authority should decide whether that excess land is there or that land belongs to me, my lord. That much is to be decided, my lord. Because if the case remains here, nothing will come out, my lord. Because the impugned order already been executed.
But the question is in regards to the decision of the DC whether the access land belongs
Yes.
to you or it doesn't belong to you. That much only has to be
Yes,
decided.
yes.
But whether DC can decide this one.
My lord.
Suppose your position, your rightly interest over the 3 lectures of land.
Yes.
Can DC be decided this thing?
DC, my lord, before removal, at least DC should give me some suppose opportunity should be given to me, my lord. Because the provision says,
No, but you remove the nuisance or whatever by yourself or who?
no,
They
they have
already-
removed it. They have removed it, that too without giving any show cause to me. And that cannot be, that is absolutely illegal, my lord. The power doesn't give any authority to remove that excess or whatever it may be. Some opportunity should be given to the party, and section 133 is clearly mentioned that show cause notice should be given to me. Now I want that, my lord, that matter is to be decided whether this is an excess land or this land belongs to me. I want to place every document, my sale deed, everything. Let that be decided.
Lordship, my lord, kindly see the which order he has been silenced. He was silenced, the order it is 6-4, Lordship. The person who passed this order, my lord, he was not made a party. Lordship, how can Lordship can give a direction to the respondents who was not made in the party, Lordship?
State.
So this petition is not maintainable as because the non-regional party of the, my lord, respected, my lord, that respondent, Lordship. Suppose, Lordship, my learned friend is saying that, my lord, DC can proceed according to the law. But without made him a party, Lordship, how can Lordship can give up order, Lordship? So you go and proceed according to my lord, the procedure of law, Lord. Only, my lord, that they have made party, my lord, the principal secretary, revenue department. Revenue department has nothing to do in this order, Lordship. Deputy commissioner, the concerned district magistrate, he is the, my lord, the person who passed this order. But he is not made a party in this petition. In this, my lord, the criminal petition, Lord.
That is under the
Lordship,
revenue
Where is
department.
the
my
order
lord.
of 6-4? You have an X 6-4?
Lordship, can you see the page 23, Lordship?
It is filed by additional district magistrate, ADC.
Lordship, my lord, Lordship, kindly see the respondent who made party, Lordship, in this petition. Lordship. The complainant, there are 27 numbers of complainant, only one has been made party. And my lord, the respondent has been, the respondent number 1, the principal secretary. Principal secretary has nothing to do in this my lord, petition. It's a district administration, they have been doing this thing, Lordship. Even when they are not by the party, but district administration.
I know it is magistrate, it is under the revenue department. That's why.
Suppose Lordship will pass give a direction, Lordship. To whom Lordship can give a direction? If he is not a met party.
Even for also hearing.
Lordship.
So 2 ways, either we can dispose of the petition down to non-maintainability, or you can given be one chance for improvement of the party. That much.
That we can do by.
Then Lordship can pass this order, what learned my friends and this deputy commissioner can do. Even
They will come in.
Lordship, yes.
Okay. Hard Mr. Discharge, and it's counsel for the petition. You're Mr. A. Someone.
No, I am J. Hendrik for Revenue Department.
Oh, sorry.
Respond number 1.
J. Hendrik, appearing on behalf of respondent number 1.
One week.
Okay. SC, no, J. Hendrik, the standing counsel, person appearing on behalf of the state. Submitted by Mr. Sharma that the in person to the order of dated 6/4/2024, the nuisance has already been removed from 3 lessons of flat, which is in disputed pending. Accordingly, Mr. Sharma submitted that the prayer, no, submitted that the petitioner may be given chance of hearing and better will be demanded by the deputy commissioner. So in that context, Mr. Henry, with understanding of the department submitted that the order which was put to challenge dated 6/4/2024 was passed by additional district magistrate Nemaji, and the ADC of the ADC is not made part here in this case. Which order is no, so accordingly, he submitted that the petition may be disposed of due to non-maintainability for non-impeding party necessary for non-impediment of necessary. Next, Mr. Sharma submitted his given opportunity to file an affidavit for impediment of no for additional for necessary petition for impediment of the impediment of the deputy commissioner as a party response. Considering this submission made by council and that the matter be listed after 3 weeks and updating the petitioner to file an interlocutory application for implement of Deputy Commissioner Mati as a party response. List the matter according.
Within 1 week, my lord, we will file. A date may be fixed after 1 week, my lord.
Fix it date, okay. My learned friend file within 1 week. Then give it, my lord, there after 10 days.
10 days, then date may be fixed, my lord.
Fixing a date is very problematic for us.
Okay, fix it on 8 lawsuit.
8, 9.
It says that 9 can be.
9.
9 can be. Okay.
Good day.
9. Oblige.
In this criminal petition, my lord, we have silenced the order of the proceedings for quashing, my lord, NI case number 532823, my lord. During pendency, my lord, we had compromised the matter, and in that regard, we have filed an additional affidavit. Flag C. In additional flag C, my lord, lordship may kindly peruse para 6. It is 61 last portion and 62. They have appeared, my-
Because it was a case of NIA and yes, anything to be submitted, Mr.
They have filed an NI case against me, my lord,
Yes.
for which we have moved before this court.
That the party of compromise.
You're Mr. Bora. You're Mr. Bora.
Bora, D. Bora.
Part Mr. D. Bora. Yeah.
In the NI case, Yashok Taba was represented by her attorney, Nirmali Chungkrang, who had signed a compromise petition.
Yes, attorney.
Yes.
Attorney.
Attorney.
That's number 3.
Three.
Response number 3, representing response number 2.
Nirmali Chankrang had the power of bar attorney.
Yes.
So she appeared on behalf of number 2.
Number 2.
Number.
I mean, she put her signature.
Yes.
Compromise deed, they have been annexed? No.
Annexed. Annexed and original also with me. Flexi, we have already annexed.
Yes. Yes. Expert is expert is submitted by Mr. Bora and asked for the petition that the matter has already amicably settled between the parties. And in this effect, one additional affidavit has also been filed, which is tagged with the present case, along with the compromise, deed of compromise.
Made on 22nd July 2025.
22nd July,
2025.
which was executed on 22nd of July. And the response number 3, MS Nirmali Chankrang had put her signature in the deed of compromise, being the attorney holder of the response. The subject Mr. Bora that matter has already been amicably settled between parties. Parties are not the petitioner is not interested in proceeding case further and for wait for closure of this. Next point, submitted also submitted in this regard that as the matter has been set, the respondent also has no objection in the present petition. Considering the submission also both sides, and also considering the fact compromise between the parties and the deed of compromise executed in pursuant to a compromise between the parties. Court is opinion that the case may not be when so the present petition is hereby closed and both the parties may be hereby directed at the learned trial court with a prayer for compromise and disposal of the case. In view of this, okay, then you can appear.
Is that 229?
On or before?
On or before?
On or before.
My lord, I have a small prayer, my lord. In this quashing petition, I have read that petitioner can be moved from Lakhimpur to Guwahati, my lord. On that he will be appear or through his lawyer, I have given the original deed of compromise.
That I cannot. That I cannot.
He will appear.
You appear, the direction is that both the parties will appear. If there is any inconvenience on your part, You can make a prayer before the court because matter has already been compromised. So I think it will be considered. So before
Obvious.
before 2-9,
Or later on, as per convenience of the
okay, then we'll don't fix any date. We'll be just passing the order.
passing the order.
before
Because
the
two
flag
two
would
nine
be-
is very recent date.
Huh?
29 is very recent date, my lord. He have to come from Lakhimpur
What
to
you
Guwahati.
saying? On one hand, you are saying that they want to appear before. On the other hand, you are saying that
Okay, madam. Obvious.
on the next this fixed. We'll pass
Obvious,
the order.
make
If any problem is there, you can make a file a petition before the learned trial could be looked.
Obvious. Obvious.
On the next date of listing. No, next date of listing, directly to appear before so and so it's honor before the next fixed date by the learned trial.
Obvious.
Order. No order. I get that. Really. Stay. Not appears on property. I declare it's a matter I got as an edit.
My lord, in this matter, a report was called for, my lord. Matter relates to Jimma vehicle, my lord.
Yes, Goswami, any report?
Not received.
Pardon?
Report not received, my lord. To pay for a date, man.
Not received.
Regarding, we have sent for a calling for report, my lord.
A Gupta, the done it of the petition, so that Mr. MP Gupta, the done it, PP, every subject instruction. The report will not be received. Stop. Reminder may be issued, calling for the notice. Directing the I to furnish the report on when it can be listed.
Lordship, on the Sip Sagar, my lord. After 10 days, my lord, let it be on some cases.
9th of September will do.
9th.
9th of September.
Lordship, 9th.
9th.
Obliged.
Let's first of all just say it is a I is for suspension.
Yes,
Not
Lordship.
going to hear the suspension.
Yes, Lordship.
Will hear the matter because otherwise it is ready for. I think you have received yes report. So fine.
Once, my lord, it's for, my lord, came up for hearing for several times, but due to paucity, my lord, it cannot be heard. That is why again, it was listed for orders for, my lord, consideration of the bail, my lord.
And Lordship, more
But-
particularly, Lordship, on two occasions, Lordship, one in the year 2024 and another on 11/2/2025, Lordship. Matter was heard at length. It was kept as part of. Subsequently, Lordship, that matter was released on 18/2/2024. So my prayer would be, Lordship, may kindly take up the IA, Lordship. My prayer would
No,
be.
I'm not going.
Matter was heard, Lordship. IA was heard.
Part heard by.
What, Lordship? Part heard by Justice Malaysia Nandiway.
Oh, अच्छा.
Released, my lord.
Released.
Therefore released, Lordship. So, Lordship, I will argue, Lordship, only three small grounds, Lordship. One is, Lordship,
No, actually, we have
3
some
years and
issues, pending works are there, so
Yes.
it not be possible.
And regarding
There
also,
are
and in
some 10 also.
NDPS cases, 389 is very, my lord, very strict, my lord. Suspension is
Very strict,
very.
NDPS, very. Do one thing, otherwise, this appeal are from of 2023.
23, Lordship. I'm in custody since 3 years, 7 months, and 10 years.
What was the term of your?
10 years, Lordship.
10 years.
10 years. And so far as NDPS is concerned, Lordship, I'm specifically relying on Lokhinder Singh's judgment, Lordship. Section 37 was dealt with.
And on the basis of that, Lordship, Akhirul Islam, Lordship was pleased to dispose of that case, Lordship, referring that provision, Lordship, and in that case, bail was granted on 2 years, 6 months. Lordship. So those would be my limited argument, Lordship. And apart from that, Lordship, I would argue on violation of Section 4.
No, we are going here.
Yes.
Dates of the hearing to open. Well, the advocates, it is no way out. They said we insisted for dates and we are giving dates now. Just we have called for the list of this court. So surprising that many matters have been fixed. So even in hearing day also, that's why I thought that one day should be there so that it can be heard. Or maybe fixed at 2. Maybe order may be there at 2 so that it can be heard.
Yes.
Where it can. He is saying 16/9 is Tuesday. So at 2.
16/9.
16/9 at 2. If you give the complete date, then it may be hard of that.
And
in both the matters are, connected, I think.
yes, Lordship. Two IA were there, Lordship. One has been disposed of, Lordship. Bail has been granted, Lordship. In the same case, Lordship, 2 brothers. One was convicted for 10 years, another for 5 years. The person who was convicted for 5 years, he has been granted bail. IA disposed of.
Okay.
And this is for 10 years, Lordship.
He is for 10 years.
Yes, Lordship.
Because 50% perhaps that.
And he was granted bail, Lordship, after completion of 1 year, 3 months. If we count in that way, Lordship, then.
Now see, in fact, I is a very particular because we cannot hear the entire matter in name of I. Your matter may be different. Otherwise, I'm saying. Because there are some specific points on the basis of which I may be considered.
Yes,
But
Lordship.
otherwise, if you go to hear the entire case on merit, then there is no point of hearing on I. Anyway, we are fixing it on 16/9 at 2 p.m. So that it may be hard.
Yes.
If it is 2 p.m., then
yes,
may be hard. Maybe hard, or otherwise it may be will come and then. আপনি একটা কাম করিব। All our matters we take them.
Lordship, may kindly fix the time also at
2 p.m.
Yes, Lordship.
That's why I'm fixing this.
Yes, Lordship.
It will Mr. M. Ahmed and so hard. I may be heard along with as the case is ready for hearing, the I may be heard along with the criminal appeal number 245 and criminal appeal number 228 of the 2020. Please the matter accordingly on 16/9/2025 at 2 p.m. for hearing. Matter may be listed at the hearing. Okay. At 2 p.m. on the hearing.
My lord, fixing for hearing.
Fixing it for hearing at 2 p.m. on the item. So
Hearing for the IA.
no, both entire
Entire.
matter. That's why I'm taking on
Yes,
time.
sir.
2 p.m. on 16. And we'll ask the rest to go, less numbers of matters so that it can be heard. What is your IA for?
Yes, my lord, this appeal is appeal against acquittal, my lord. Appeal, then there is a delay, my lord, in connection of this appeal, 86 days delay, my lord. And there is a rectification, my lord, for correction of the delay period hereafter.
So what about 1, 2, 3, 4?
My lord, in this case, that's
Because it is against acquittal, na?
acquittal, my lord. Informant
Service report regarding service report. Not been received yet. Have you taken the steps?
Yes, my lord. Steps is taken, my lord. And previously it is one time listed, and there was an order for waiting the service report last time.
So state is also a respondent, I think.
There is no from the respondent side.
Uh-huh.
And PP is also one of the respondent, my lord.
Oh, he has
State
to be.
government.
So your respondent number PP কি দিছে ইয়াতে? গম পোৱা? You have not made party? PP have not made party?
My lord,
It is
there are
necessary party. It is an equital, isn't it?
private party here as a four private party.
What kind of case?
Ganik Haloi, Amulya Haloi, Rina Haloi, all are residents of the same family, my lord.
Family is okay. This is a case of your equital or whatever the case was registered under which section? This is IPC case
Yes, my lord.
on the basis of an FIR or what?
On the basis of the FIR, my lord. In
FIR,
this
then what if
case,
PP is not there, you are not there.
It is my appeal not yet numbered, man.
No, not in number is okay.
Yes.
There was a delay of some days, I think.
Yes,
It's a
yes, that is-
interlocutory application for under 5 of limitation.
Lordship.
But the question is that you are not the party.
Yes, ma'am.
You're supposed to be party here, na? State.
Yes, state has to be party in appeal.
State is not the party. So why three?
my lord, before filing this criminal appeal, my lord, by the complainant party, my lord, this is the victim, my lord. She approached to the session judge Nalbari, my lord, in a wrong direction, my lord. And there the case,
It's
her
okay,
appeal
there
is
are,
dismissed.
There are reasons for delay. I can understand. That is okay.
Dismissed. Then
Simply
she,
Renu Haloi is the victim.
yes, my lord, Renu
That
Haloi
is
is
understood.
victim.
And then three petitioners, I mean, respondents are there four respondents are there who got acquitted.
Acquitted.
No, it's
Appeal
okay.
against-
But I'm saying that why don't you make party, the
Yes.
state respondent,
We-
it has to be party, na? He is not the party. I mean, state is not the party.
So respondent of 5 number police.
It's already added.
I have impeded.
Impeded?
I have
It was a-
impeded respondent number 5 as a state.
respondent.
State.
কোন ঘৰত?
There is a one IA maybe, most probably
IA.
it is IA.
সেইটো আয় দিছে, LP নে?
There
This
is an
LP.
order, there is an order to be, to make the party state government as a respondent number 5. And thereafter I make the state government as a respondent number 5.
Maybe. I agree.
I1 is for LP.
Yes, another, yes, one is for LP and another for condonation.
But unless and until the delay is condoned, that cannot
Yes.
be, but the question is not, I'm not finding it. Already. I mean, I found I. Condonation of high. If you order the get it order. Yeah. Mr. Gusami, one order is there.
Yes.
Wherein state is the party.
Yes.
I mean, one order is passed. Raised it to make necessary corrections.
Yes, ma'am, raised it.
Interlocutory.
Perhaps raised
That
it.
has not been.
Not been made, that is why problem. Lordship, direct, as per the order dated.
Raised পূর্ববর্তী দিতে। Raised করে দিন। And what about the other respondents?
In case of other respondents, I have taken the steps, my lord, for
It
service.
has not been returned.
last time, the order is passed for awaiting the service report, my lord. But what is done then officially, I do not know, my lord. I have not passed out the record, my lord.
It's seems that it is still awaited.
So
You
sometime
have any
maybe
other
we'll-
source through jurisdiction, police station also you can.
So your
Suppose if it is still awaited, suppose, I'm just suggesting, it may not return, so through jurisdiction, police station, that can be done.
okay.
Then that it may, be service may be there then. Nice.
To the concerned police station.
I guess. Hard Mr. Okay, sorry, hard MF PRA Sultan. And it comes to the petition. Also part of petition first. From the fiscal, it revealed that the service is still awaited for response number 1, 3, and 4. In that context, the petitioner is hereby directed to take steps on the respondent number 2, also sorry, or the respondents. True. In that context, sorry, in that context, the notice may be issued to the respondents to who are in charge of the petition station. The petitioner will take steps within 2 or 3 days. Next paragraph, further, from the order dated 7/2/2025, it is seen that the state was asked to make party the present case as respondent number 5. And the registry was accordingly directed to do the necessary correction in the cost statement of the petition. But it is seen that the correction has not yet done by the registry in view of next paragraph, in view of this. The registry is thereby directed to make necessary correction, including the state as a respondent number 5. Further, the registry is also hereby directed to reflect the name of the state respondent as party respondent in the case on the next date of post. Listed accordingly after 2 weeks. It will be listed after 2 weeks.
Good.
34.
34. 35.
Yes,
May I please, Your Lordship? Lordship, this is a matter under NI Act. Notice was already issued in the appeal. This is only listed for recalling of the non-bailable warrant. Well, that order was not there, which we have filed through an additional affidavit, my lords. The NBW issued by the learned trial court, my lords. This is in revision against the appeal. Let's in page number 58 of the additional affidavit, my lords.
58.
It's an order dated 16.
It's
An order dated 16 July 2025, my lords.
$58.
Yes, my lords. Order dated 16 July 2025.
So that order was earlier, you have not annexed the order.
Yes, my lords. Yes, my lords.
Then now?
Now, my lords, we have annexed the order. And since the NPW have already been issued, my lords, and appeal has, revision has already been allowed by this honorable court, my lords. However, since the NBW is pending, therefore we have annexed this order with the additional affidavit so that this NBW issued by this order may be recalled, my lords.
Therefore, we are saying your revision is admitted.
But in order dated 6, not admitted in the sense, my lord, notice has been issued. 6 August 2025, my lord. Of this honorable court, my lord. Notice was issued.
Fine. It was simple an order. We are not in a position. didn't peruse the record and also this simple order was passed for issuing notice on the respond number 2.
Yes, my lords.
So now you have annexed the additional affidavit, it's okay, but the question is that where is the order?
Which order, my lords?
No, no, you're saying that it has already been, notice has already been issued to
No,
respond.
so if I may sum it up, my lords. So basically, this is a case of NI Act.
NI where
Trial
NDW
court has convicted the my lords, the
Yes, yes,
petitioner.
NDW was issued.
Then my lords, no, my lords. So basically, there was a judgment of the trial court. Then the trial court judgment convicted the petitioner. Then thereafter, we went up on the appeal. Appeal was dismissed.
So yes.
Dismissed.
Dismissed.
Then, my lords, then it was sent to the
Sent back.
trial court. And within 30 days, my lords, we have filed this criminal revision against that appeal, which has convicted us, my lords.
Within 30 days?
Within 30 days, my lords.
So that order of appellate court is dated?
Dated, my lords, 14 July. That is, my lords, in page number 18 of the revision petition, my lords.
And you have filed this one revision and
Revision against this, my lords, this appeal.
yes, when you file revision, your revision?
My lord, this was filed on 30th of July, my lords. So the first time it came before the court was on 6th August for hearing, my lord, for motion. So that is within, my lords, 30 days.
So you annexed the order of 30/07/2025.
No, my
And
lord.
the earlier order?
No, my lord. So basically what happens, my lord?
16/7.
16/7, yes, my lords. So basically what happened, my lords, 14 July appeal order was given, then immediately on the
16/7, immediately on 16/7?
my lords, it went to the trial court. My lord, and by the time we could file the revision, they have issued an NBW, my lords. And therefore we are for this court for recalling of that NBW.
But as NBW has already been issued, you are not in the previous bill.
Not on previous one, my lords.
So you have to surrender.
Yes, my lords, that's the problem. We are apprehending arrest, my lords.
Parties for the learned. Parties. Yep. Is interpreted twice for stay of the current estimate. First implementation is 14.7.5 passed by planet section criminal acting number 18. Inadvertently, a order of
Additional CGM.
order of additional digit. And 38 annexed along with the connected criminal revision petition at the time filed, whereby the order of issuance of NPW was passed by the Council, for which to an additional scope in connection with connected criminal petition. Some some the order the after the order of the appeal, the order 14.7, order of the appeal dated 14.7, the court was immediately sent back to the attorney general. And on section 7, and immediately on the receipt of the court, section 7, order of the order of the was against it. For the subject to perform that criminal fine within the statutory limit 130 days, but before expiry of the statement, the NPW was issued against the present by instant it is paid for stay of the execution of the and also to recall the NPW the other aspect the order of and it is 14.7 past 14.7 past in criminal actions is hereby and further the petition of the NPW issued against the directing petition to appear before the learned trial with an appropriate allowed to remain on bail and subject to satisfaction of the learned trial bail amount to be considered. It's reliable and actually the bail amount directed to surrender before the learned trial done by an NPW is thereby recalled and petition is paid or with an act or with 20 responsible back to the satisfaction of the learned trial. The petitioner is further directed to what is the compliance report. on next- In connection with determinant. 302, okay. With the above observation. That's- in-
We have taken steps in that.
No, this, the service is still awaited.
Still awaited.
NCR questioning can. Notice issued against the respondent is still awaited. Further copy of it also reveals that the LCR as called for is also distributed within it. Is the matter.
I'm so obliged. Grateful. Grateful.
May I please, your lordship?
Yes.
This criminal appeal against conviction, my lord, under section 10 of the POCSO Act. And there is a delay, my lord, 96 days delay in preparing this appeal.
So you are engaged counsel or legal engaged?
I am legal aid counsel, my lord. And in this IA, my lord, step is taken by Talavana, my lord, on 21/3/25, my. Sorry, on 2/5/25. To the respondent number 2. Informant.
You have through the office of the PPA, I think, because it is a POCSO case.
Yes, my lord.
Then furnish a copy so that they can also print. We are listing it after 2 weeks. We'll see.